Good morning. It's Thursday, January 16th, and the time is 9 a.m. Thank you all for attending the Peace Officer Standing Accountability Advisory Board hearing. Please note that this hearing is being live streamed, recorded, and transcribed. Further, please note that the microphones are auto on-off. When you begin speaking, they will go live. With this in mind, you'll need to watch your crosstalk. We will now start with our roll call for our board meetings. Mr. Knapp, please take roll call.
Good morning, members of the board. Welcome. Good to see you today. Board Member Buchan. Board Member Clavo.
Present.
Board Member Crawford.
Present.
Board Member Doyle.
Here.
Chair Dudley.
Here.
Board Member Glaser.
Present.
Board Member Johnson.
Present.
Board Member Lara.
Present.
And Board Member Pena.
Present.
Thank you.
Okay, so it looks like we're just missing one person, and quorum has been established. I would now like to introduce Board Counsel Christopher Beatty and Board Assistant Executive Director Anne Marie Delmio. Right? And this time is set aside for members of the public who wish to comment on items not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item is presented. Public comment on specific peace officer revocation cases to be heard today will be heard at the time of the hearing of each subject matter. Please be advised that the board cannot take action on items not on the agenda, but only to the extent necessary to determine whether they should be made an agenda item at a future meeting. Respond briefly to statements or questions posed. Request clarification or refer to the items to staff. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. As the board chair, I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute set aside for public comment has expired. You'll be giving 4 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your thoughts within the allotted time. Before I open public comment on matters not on the agenda, please note that if you have a specific complaint about an officer that is not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Staff will assist you in that regard. And I'd like to remind individuals making comments to not discuss pending complaints or pending disciplinary actions that may later come before the board for a recommendation. If the board takes action on your complaint, you will have an opportunity to address the board at that time. Following these rules is necessary to comply with the law and to avoid compromising the board's mission. So at this point, is there anyone present in the audience or appearing remotely who would like to address the board during public comment? Looking into the audience, I see no one. And do we have anybody online? No. Okay. Okay, so now we're going to go on to the minutes of the meeting. Is there anyone present or appearing remotely by phone who would like to address the board regarding the approval of the October 17th, 2024 transcripts? When it is your turn, you may state your name and or organization if you wish. Anybody want to comment on the agenda? Remotely? Okay. Are there any questions or comments from the board? Seeing none, hearing one. If the board concurs, the appropriate action would be a motion to approve the meeting transcript from the October 17th, 2024 meeting. Is there such a motion?
Second.
Thank you. Second?
Second.
Any opposed? Any abstentions? We'll now call roll to vote on the approval of the minutes and transcript. Ms. Knapp?
Clavo,
Aye.
Clavo, I, Crawford.
Aye.
Crawford, I, Doyle.
Aye.
Doyle, I, Dudley.
Aye.
Dudley, I, Glazer. Glazer, I, Johnson.
Aye.
Johnson, I, Lara.
Aye.
Lara, I, Pena.
Abstain, I wasn't present.
Motion passes.
Okay, thank you. And that passes. At this time, Post Assistant Executive Director Anne Marie Delmuneo would like to address the board and introduce the new business items. Ms. Delmuneo?
Thank you, Madam Chair. Good morning, board members, and thank you for your time this morning and afternoon. I think it's going to be a full day. There are no new business items. However, I wanted an opportunity to address the committee report that was sent to you previously regarding cases that were heard at the last board hearing that were heard by the commission on November 21st, 2024, to answer any questions you may have regarding the status of those cases. Are there any questions regarding the report? Okay, no questions. The only other item we have before you today in terms of administrative reports is our data report to go over some of the statistical data profile information that we try to provide to you at each and every board meeting to give you an update on the volume, the status of complaints, charges, and allegations that come before the board and the commission. And with Dr. Glazer's help, we started refining these. We've got a long way to go, but we've done some things that we hope will help paint a better picture of 33,000 complaints, charges, and allegations that come in. Where do all of those go, and what's the status of those reports after they're through our intake bureau? So I'd like to invite Bureau Chief Christine Ford to come forward. She will be providing the report for you today.
Morning, Chair Dudley, board members. Be happy to provide you with the up-to-date on the statistics for the division. Okay, as you can see from our statistics as of December 31st, there you go. Our top 3 areas of serious misconduct allegations remain physical abuse, excessive use of force, demonstrating bias, and abuse of power. As you can see, we have over 31,000 agency misconduct reports that have been received, which are unique to over 18,000 law enforcement officers. We do, as of right now, have over 82,000 officers in the state. 53% of those 31,000 are retro or look-back cases. We've taken over 1,400 public complaints, 9,400 unassigned reports, and I'll explain a little bit about what unassigned means on a later slide. 22,000 of those 31,000 cases are now cases, which means that they've been assigned to personnel to actively work. 12,000 those are open, and 9,600 we have closed. Next slide, please. So if we look at our agency misconduct reports, as we talked about, 9,400 are unassigned, 12,000 are open, and 9,000 are closed. And I will talk specifically about each one of those categories on the next slides. Next. Unassigned reports, the best description I can give you is that they are not actively being worked by a law enforcement consultant or our staff. How we break those down right now are priority 1, 2, 3, 4, and open cases, open investigations, which basically means that are open with the agency. As a reminder, our priority 1 cases are cases where the agency has a sustained finding on the officer. Priority 2s are the same thing. There's a sustained finding, but in a further investigation, we find that it does not meet the definition of serious misconduct. So on some of those cases, we will not move forward with. Priority 3s are cases where the agency has a unfounded, exonerated, or not sustained finding. Our priority 4s are cases where those were our retro cases where due to the date, we could not take action on them. And again, if you look at the open investigations, those are cases that the agencies have not completed their investigation. So if you look at that slide, our open investigation and our priority threes, they basically are 95% of our unassigned cases right now, or unassigned reports. Next slide. Our current open cases right now, as you can see, over 10,000 are open with post. 5 you're going to be hearing today, which are going to the board hearing. 6 are pending executive review. 2,500 are open with the agency, and then those other numbers show some of the progress that some of the other cases we have. As you can see, the majority of the open cases right now are with post. Next slide. Our closed cases, as you can see, 9,000 are no further action. Some of the descriptions I want to just provide just briefly. Disqualified means that we closed the case, but they were disqualified, which means that they didn't have a basic certificate or a POE. So basically we revoke them, but they didn't have anything to revoke. Ineligibles are our folks that fall under that government code 1029. Issued in error, those could be an example of where an agency submitted a case twice, which in turn we would issue that one case in error. And then no commission action. Revocation are our cases which they've been revoked, and then suspension and voluntary surrenders. But as you can see, the bulk of our closures are post chose to review them and do an investigation, and there was no further action. We closed it. Next. So if we break down some of our no further action closures, which we just talked about, 49% fall under the category of not serious misconduct. We did the investigation, did not meet the definitions of serious misconduct. 34% we closed with not clear and convincing, which means that during the investigation and the completion of it, we could not get to clear and convincing evidence, which is our threshold for evidence. And then not actionable, 17%. The bulk of those cases are we couldn't take action based on the date of the occurrence. Next.
Let me interrupt for a second.
Sure.
I'm a little concerned. I'm not sure I understand what not actionable is.
Those would be our retro cases where based on the date of the closure, we could not take action on it. So as of the date, we have 39 notice of intent to revoke letters that have been sent out. To break those down, out of those 39, 15 have appealed. 22 were defaults. One was a 1029 revocation, and then one was a voluntary surrender. Some other certification actions, government code 1029 ineligibilities is 123. We've had 71 voluntary surrenders thus far and 85 revocations. Now, some of these slides I'm not going to cover. I will take questions if you're interested in, but I do. Yes, member. Yes,
I didn't know if it was appropriate
sure.
to ask. Could you go back like 4 slides? One right here, the 224 issue in error, probably like a 1%, probably of all the cases, probably less than. It's probably less than, but still enough, 224 is kind of a high number of, issues in error. So I want to compliment Ms. Anne-Marie and Director Alvarez for taking their time at one point to come to Ventura County to talk to all of our law enforcement agencies to discuss SB2. And I just kind of wonder if that type of outreach is continuing, and if this will probably lessen an issue in error, because that's a number that we shouldn't even have on there. If possible, you did excellent job on it. Issue in error, so that's was my only comment about it, was the 224 number.
Yes, thank you for the comment. I know that our Mark 43 trainings have begun, and we've reached out to a lot of agencies to put on Mark 43 training on a monthly basis. We also have all of our bureaus go out, and this year we've concentrated on some of the associations to go out, like you said, in Ventura, to reach out and continue training. I do want to note that one of the primary reasons there's an issued error, which I mentioned, was a double entry. It could also be that we've had agencies input the incorrect post ID number where an officer is put in and it's not really exactly the officer. So, and that's human error. And so we have talked to agencies about ensuring that they're putting in the correct number. So those would be examples of the issued in error numbers. So we look for that number to decrease as we move forward.
Thank you.
Right, that's something
Yes,
to that.
sir.
And just so you know, the post number is also, I'm a former training lieutenant, so there are oftentimes very strange, not intuitive assortments of like, almost like a code password. So there's, if they're hand keyed, that's gonna be a place where that human error can take place. They're not necessarily intuitive or alphabetical, they're random kind of groups of numbers, so that I can see where that human keying error can happen.
Along those same lines, there was a report by public versus a report by agency. How often do you get a report by public, which is also a report by agency, and how does that affect your statistics? Does it?
Yeah, I got your question to the last section.
Okay. Go ahead.
What I wanted to actually, it'll kind of meld into the future slides that are on here is, so for public complaints, we take, it's increased. We've taken over 900 public complaints from last year, and prior to that, 500. So you're looking at an almost 47% increase as we are moving forward. Many of those complaints do become and are already reported by the agency, but some aren't. I don't have the specific numbers as to how many actually are reported already and which are new.
Yes, and is that number public? So that number could be duplicative at this point.
Correct.
So when we were looking at that number could be 50% already the agency had reported. I'm just making up the 50%.
I don't think it's that high.
Yeah, I don't think so either. Sarah, do you want to approach, please? So our Bureau Chief for Intake and Disposition Bureau, Sarah Wallace, can speak to that. If there was a duplicate entry, we would merge those cases. So that AMR would probably basically be obsolete because we wouldn't maintain two, cases against the same officer from different complainants, if
Got
you
it.
will. Yeah.
Morning. My name is Sarah Wallace. I'm the Bureau Chief for Intake and Disposition Bureau. So as Anne Marie mentioned, when we receive our
I think I
public,
need you closer to the mic closer to you. Thank you so much.
as Anne Marie mentioned, when we receive public complaints, our Intake and Disposition Bureau does a review. We review to see if we've already received an agency misconduct report or the agency's already reported that. If they do, then we link, it's called linking a report. So it comes into the same case jacket. And so it's all reviewed at the same time. If we come across a situation where we have not already been notified by the agency, then we work with the agency to get the appropriate information. And I know, as Christine will mention in her report, there are some public complaints that come in that are serious misconduct allegations, but a great majority of the complaints that we receive are not serious misconduct related. And so many times those will be closed out. We'll reach out to the agency, confirm nothing had happened, and move those along.
Not to create more work for you, but I think we'd be interested. First of all, when there's a duplicate reporting, I think that's a good thing. That means both the agency and the public are on the same page when they made that. But then it would be important for us as a hearing board to know how many of those public complaints did not rise to the level of serious misconduct. So it'll give us a better handle on that, because there's been lots of discussion since we've been created about, geez, the agency really passing things on, geez, the public really communicating with you. So I think, shining a light on that would give us more information if possible.
Definitely. We'll take that back and look at what we can provide in future reports as it relates to agencies that have already reported or have linked agency misconduct reports. And I think some of the information Christine has also sheds light on the breakdown of serious misconduct versus non-serious misconduct as well.
Anything else on that? Yes.
I did want to add one more thing. Fred is wonderful. I would like to say something positive. I think, if you were to look at it at a quick glance for the public, and I'm just speaking for me, the first thing is always alarming when we see that 32 number from where we started to where we are now, where the board has been in existence approximately about 2 years. It's alarming because it's a quick look and you don't look like we're seeing any movement. I'm glad that you gave us this breakdown, but is there any way to create like a kind of something that gives the public the sense that these cases are moving along and at a quick glance, so, because it's like that 10-second, 30-second elevator thing.
Yeah.
People see it, they look at it, and all they're gonna remember is that large top number. And of the small top number, right? And so I'm just concerned that as I think we're doing an effective job, I don't think the public is seeing it. Especially like I said, if I had to look at that report at a quick glance, that's what's gonna stick out in my mind. And maybe I'm asking too much.
No, you're not. And we're continuing to kind of fine tune the visuals on this, right?
Okay.
So I think the point is exactly what you said. You see 33,000 and that's alarming with 82,000 peace officers. And now you see 33,000 complaints, charges and allegations, not cases, but the public doesn't distinguish between those two and we shouldn't expect them to. But that's why we're trying to break down 10,000 of those were not serious misconduct. Another 9,000 are in investigation. And then you have that number that's unassigned because it's waiting in queue because those were the complaints, charges, allegations that the agency investigated that were not sustained or the officer is no longer working. So those are a less priority case. So I think just having that on one page in some sort of graph or pie chart or something will help, I think, distill that 33,000 number into something that's a little more palatable as to what the actuality is of cases that look to be serious misconduct. They fall into one of the 9 categories and they're in some stage of review by post. And that's our end goal. So every year we do a report to the legislature that is supposed to do just that, right? It's kind of distilling that information. So it's something that they can take in and understand the volume, the scope, the staffing levels of post, how quickly we can really address these cases that are coming before us. So as we work to look at different opportunities for those graphics, we will provide you perhaps different samples for you to look at to see what's the most digestible for you at a quick glance. I think to a question our chair had, Chair Dudley had a question of those public complaints, how many of those actually are not serious misconduct? Because the public doesn't have the full breadth and understanding of what SB2 really is. The general public, law enforcement is starting to get the full breadth and understanding. So of those, 1,400, over 800 of them, 837 of them had nothing to do with serious misconduct. So the public may go online and file a complaint, and they may be complaining about the city manager. They may be complaining about the lack of law enforcement officers for a particular, area. Time it gets, the time it takes for them to respond to a call, and those things obviously outside of the realm of SB2 and individual peace officer serious misconduct. But that's part of this learning curve that I think we're going to continue to go through for many, many years with the general public, because it's not as easy for us to reach those masses. But we will continue to provide information to you. I mean, I think it's a positive that we've seen this jump 46%, that there's some awareness that Post is out there doing some of this work. To the extent that they start to familiarize themselves with the type of serious misconduct that falls within our jurisdiction is going to take time. Over the course of the next year, and there's already many of these, I would say, presentations, town halls scheduled, we're starting to do more with the line staff, as opposed to just hitting kind of command staff, IA staff, the leadership in the law enforcement profession. We're trying to hit more of the masses in terms of explaining what happens if you get a complaint charge or allegation filed against you. What does it look like? What's the process? And I think as we continue to do that outreach, there's going to be more familiarity with it. But these are things still in the early stages, trying to even get familiar ourselves with the type of data we're seeing and what to do with that data to be responsible in reporting. You're welcome.
Just one last comment I want to make as far as the agency misconduct trend. So per quarter, we're taking in about 2,500 reports, which is quite lower than what you're going to see for the 33,000. So as the numbers trend down, it will give staff more time to address and tackle the 33,000 as we reduce that number. So that will obviously help. That's all I have. If there's any questions about any of the slides.
Questions? Yeah. First, thank you to the staff for improving this data presentation and for your responsiveness to the board's needs and the public's needs. And I just want to commend that and express my appreciation. I think on the topic of the public complaints, what could be very useful would be a separate breakdown of disposition and status just for the public complaints, because I think, with regard to being responsive to the public, it would be really useful to know that. I know that there's some duplication, but maybe even breaking out the ones that aren't duplicates and seeing what happens as a result of those. And then I think in general with respect to reporting out on the disposition of these cases, that to the extent that the decision-making can be made transparent, because when that will, I think, benefit everybody. When we say that a lot of these public complaints just warrant serious misconduct, that's pretty opaque, and that's a determination made by a staff member or members who are unknown to the public. And so in terms of valid feedback, to the extent that can be broken down even more. So for example, just doesn't fall into one of the 9 categories, or it also goes into a determination of not serious. So that would be useful. And then one very specific data question that I had, on one of the slides, it says that there have been 83 revocations on the closed cases slide. But then there have only been 39 letters of intent to revoke. So how do we reconcile those 2 numbers?
Any of those could be voluntary surrenders. Or
They also include our 1029 revocations. And so those 1029, so for disqualifiers, and through government code section 1029, those cases do not come to the board because they're automatic. And so those revocations are also included in that total count.
Letters of intent would just be cases where there is a determination of serious misconduct reaching clear and convincing evidence. And then, but there hasn't been a voluntary surrender or a 1029.
Correct. So we have 2 separate pathways. So we have the 1029 revocations, but then for those 39 letters of intent to revoke, that's the letter that triggers the potential to have a board hearing. If they do not appeal, then they do end up in a default revocation status. Again, those cases do not go to the board because they failed to appeal. Those that do appeal would move forward to the board.
Dr. Glazer, one other thing, just to qualify 1029, primarily felony convictions, some qualifying misdemeanors. So when we talk about 1029, this is by operation of law, that if a officer is charged with a felony or a qualifying misdemeanor, which they're enumerated in 1029, they cannot be a peace officer. They are disqualified. And the law essentially says through Senate Bill 2 that posts shall revoke. So there's no discretion on the part of the board and the commission. They're revoked automatically, basically by operation of law.
Dr. Glazer, when you were talking about the further breakdown of public, I'm envisioning something like a checklist, but I understand shining a light on it, there'll still be some confusion about that. But if, there were 6 different things and one of them was did not meet the elements of serious misconduct, another was outdated, things like that. Were you thinking something like that, or were you thinking highlighting more depth?
I wouldn't know it until I saw it, and
Oh.
we've had some conversations about this. At the very least, I think it would be useful just to provide a separate breakdown of disposition of cases that come in through public comment. But then within that, yeah, some specification of the causes of the determination of, for example, it doesn't rise to serious misconduct or it's not clear and convincing.
So
yeah.
what I'm sort of envisioning, and again, I have no idea if this is possible, is if it is a checklist, you come up with the criteria of that checklist, and then beneath that would be something that you could republish every month or every quarter, whenever you do that, which is reminding people what the serious crimes are, reminding what the statute of limitations is, if there is one, reminding about the difference between a felony and a misdemeanor. That every time you publish stats could come out, but the checklist would relate to that. So it's a possible way of quickly getting to that. I think the reason I'm so supportive of this is it gives the public confidence that why decisions are made. Because if not, they're going to think it's just made on this wild discretion and they'll be offended one way or another. That's a little more linear and possible, but in your good hands. Is that what you had in mind? Excellent. Thank you. Anything else?
Thank you. IDB will take that feedback and we'll put some documents together and bring it back to the board.
Thank you very much.
Do you want to comment on that at all?
No, I think we're good.
Is there anyone present or appearing remotely by phone who would like to address the board regarding the data for serious misconduct reporting, investigations, and the outcome of cases that we talked about 10 minutes ago, and disciplinary action outcomes when it comes to your turn? You may state your name, organization, et cetera. So we just handled two areas. One is the result of the outcomes. The other was data. Anybody look here or remote who'd like to comment on either one of those things? Okay. Moving on. You have anything else?
I'm
You're
good,
good.
thank you.
Okay. I think we'll take a half hour and start. You're okay? Okay, we'll stop at 10. We will now move to the next items on the agenda. We have 4 cases to hear today. We will only be reviewing the facts and evidence as presented by the division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There is no need to make any objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this initial hearing will determine only if the matter will proceed forward for the commission's review. And then, should the commission approve for a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. For those commenting on each item at this early stage, the board must only consider the facts that the division, after investigation, believes can be proved at a later evidentiary hearing. For that reason, today, the board will entertain arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct, as defined in Penal Code Section 13510.8 and Commission Regulation 1205, occurred. This finding results in the matter being moved forward. No action by the board or the commission prior to a full evidentiary hearing amounts to a final determination that an officer did in fact engage in misconduct or that revocation or suspension is ordered. That will be determined after the evidentiary hearing. At the conclusion, each law enforcement consultant's presentation, the board will have the opportunity to ask questions, then public comment from the subject officer and/or their counsel will be taken, followed by members of the public. Further discussion of the board will be allowed if necessary. The board may then go into closed session, deliberate after each case, or wait until all cases have been presented and adjourn into closed session to deliberate on all cases presented. After reconvening into regular session, votes will be taken on each case. So a couple of things. One is, in the past, you as a board has decided after each case, you want to go discuss them. We have the option to discuss it in public, go ahead and do that after each case or discuss them all after all 4 cases have been presented. How would you like to proceed?
Discuss each one separately.
Sorry, separately? Okay, so the way we've done it in the past. Okay. Anybody disagree with that? Okay, fine. Okay, couple more things. These cases are all from the Los Angeles area. I live in Santa Barbara, and we've been living in very soft way, what Los Angeles has been going through. It is an unbelievable disaster. For those of you that have come up from Los Angeles, I'm sure your hearts are very heavy in terms of what's happening to your communities. For those calling in, again, please know that you have our empathy, our concern, our love from Post and from everybody here today. So we're going to proceed, but understanding that this is a very difficult time for all of you. The other thing is later on, we're going to have some cases with alleged statements of bias in Texas. Some of those are very difficult for people to hear, very difficult for people to consider. And I just want to again acknowledge that it's difficult to read those texts, to see the words and to make decisions on them. So again, our empathy for those people that are feeling that sense of violation, if in fact anyone is going through that. Tough cases require a tough board, and we've got you here today for that. So at this time, I will call upon law enforcement consultant Brad Ehrman, Professional Conduct Los Angeles County Bureau, and Carrie Woolley, attorney for Legal Affairs Bureau, to provide a report on case post 2400920, Tommy Thompson, who at the time of the events at issue in this case were employed with the Los Angeles Police Department. Thank you. Please go ahead whenever you're ready.
Good morning, Chair and members of the board. My name is Brad Ehrman. I'm one of the law enforcement consultants assigned to the Professional Conduct Bureau, Los Angeles County, in the Peace Officer Standard and Accountability Division. With me today is Carrie Woolley, an attorney with our Legal Affairs Bureau. I'm here today to present case post 2400920 involving Tommy Thompson, formerly with the Los Angeles Police Department. It is the division's determination that clear and convincing evidence exists to demonstrate that Mr. Thompson committed an act of serious misconduct as set forth in Penal Code Section 13510.8B6 on March 14th, 2023 and March 17th, 2023. Specifically, the division has determined that Mr. Thompson committed the following acts of serious misconduct. Acts that violate the law and that are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law when he drove under the influence of alcohol and drugs on 2 separate occasions during work hours. In this presentation, I will present a brief outline of the division's findings of investigations in this matter. Mr. Thompson began his career with the Los Angeles Police Department on June 10th, 1996. On June 25th, 2006, Mr. Thompson was promoted to the position of Detective 1. On November 3rd, 2013, Mr. Thompson was promoted to the position of Detective 2. On July 30th, 2023, Mr. Thompson was demoted to the position of Detective 1. Mr. Thompson holds the following post certificates. He has a basic, intermediate, advanced, and supervisory. Mr. Thompson has a prior alcohol-related discipline from March 13th, 1998, for which he received a 3-day suspension. Mr. Thompson's other disciplinary matters are not relevant in these proceedings. As set forth in the ISF, Mr. Thompson was arrested for DUI twice in a 4-day period while on duty. The first incident occurred on March 14th, 2023 at approximately 9:30 a.m. According to the California Highway Patrol report, Mr. Thompson, who was driving an unmarked LAPD vehicle, was involved in a single vehicle accident after he attempted to make a U-turn and lost traction. He drove over a raised curb and struck a tree located on the side of the roadway. Mr. Thompson left the scene of the accident and drove to a nearby Arco gas station where he spent approximately 40 minutes attempting to fix the damage to the front of his vehicle. Mr. Thompson then left the Arco gas station and drove to a mobile gas station where he contacted the supervisor about the accident and that he was involved in, and then he was involved in a second minor vehicle accident when he backed into another vehicle at the gas station. Mr. Thompson then spent approximately 30 minutes trying to fix the damage to his vehicle. Mr. Thompson left the mobile gas station and his vehicle became disabled in the roadway. A LA sheriff deputy discovered him stalled in the roadway and called the CHP to respond. The CHP officer conducted the investigation and determined that Mr. Thompson was under the influence of alcohol or drugs, prescription Ambien, and arrested Mr. Thompson. At approximately 13:08 hours, Mr. Thompson submitted to a chemical breath test, which showed he had a blood alcohol content of 0.03%. The CHP also took a blood sample from Mr. Thompson to test him for the omitted prescription drugs. Since Mr. Thompson's sample showed a drug in his system, the Los Angeles County District Attorney's Office charged him with a violation of Vehicle Code Section 23152G, driving under the combination influence of any alcohol and drug. On February 22nd, 2024, Mr. Thompson pled no contest to one misdemeanor count of Vehicle Code Section 23152A, driving under the influence of alcohol. The conviction included the sentence of 14 days time served, fines, and he was ordered to complete an 18-month driving under the influence program. What's the timeline up? Second incident occurred on March 17th, 2023, while assigned to home duty because of the March 14th DUI arrest. Mr. Thompson was driving his personal vehicle and lost control when the vehicle ran out of gas. The vehicle then hit a pole. Los Angeles Sheriff responded and conducted an investigation, which found that Mr. Thompson was operating his vehicle while under the influence of alcohol. Mr. Thompson provided a breath sample which showed that he had a BAC of 0.08 and 0.09. On February 22nd, 2024, Mr. Thompson pled no contest to one misdemeanor count of wet reckless driving. Mr. Thompson was assessed fines, fees, and ordered to complete an 18-month driving under the influence program, which he could complete concurrent with his first DUI conviction. The Los Angeles Police Department conducted an internal affairs investigation on both DUI arrests. The internal affairs investigation resulted in 5 sustained policy violations with a recommendation that Mr. Thompson be directed to a Board of Rights hearing with the proposed penalty of termination. During Mr. Thompson's internal affairs interview, Mr. Thompson stated that after his 2 DUI arrests, he checked himself into the Betty Ford Clinic for treatment and was attending Alcohol Anonymous meetings. On February 22nd, 2024, Mr. Thompson signed a settlement agreement with the Los Angeles County Police Department that imposed a 22-day suspension as a result of the 2 DUI arrests. And while employed with the Los Angeles Police Department for a period of 3 years, required him to 1, abstain from the use of alcoholic beverages, 2, not enter any establishment whose primary business is selling alcoholic beverages while off duty, not purchase any alcoholic beverages while off duty, 4, submit to a substance test up to 3 times a month as directed by supervisor, and 5, submit to unscheduled, unannounced directed testing for controlled substances up to 5 times a month as directed by department supervisor. The facts I have just recited support the division's findings that Mr. Thompson was involved in serious misconduct, specifically acts that violate the law. For the purpose of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Mr. Thompson's post certificate be revoked. The division recommended this based on the following. Between March 14th and March 17th, 2023, Mr. Thompson engaged in conduct that would lead to 2 separate arrests and convictions for DUI. Impaired driving is illegal because of the inherent dangers to the drivers themselves and to others. Under Penal Code Section 13510.8 B6 and Post Regulations 1205A6, acts that violate the law constitute serious misconduct when they are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligations to uphold the law or respect the rights of the members of the public. Impaired driving and repeated acts of impaired driving are acts that violate the law and are both sufficiently egregious and sufficiently repeated as to be inconsistent with Mr. Thompson's obligation to uphold the law, respect the rights of the members of the public. As a homicide detective charged with investigating our most serious crimes, Mr. Thompson's actions in driving impaired on 2 occasions established that he committed serious misconduct. With that, I'm happy to answer any questions that the board has.
I have a few. Thank you so much. I may have misheard this. In 98, was there a first DUI?
It was a alcohol related. It didn't say DUI.
What was it?
We don't know.
Okay.
I think it's based on the time.
I'm sorry, what?
And it was over 20 years ago.
Okay. In the future, if it's ever possible to get more information about, if we're looking at a second DUI, but in fact, it's somehow related, a prior alcohol offense, it's helpful for the board to know more about that. And I really appreciate the timeline there. That's very helpful. I'm trying to, now could you, Chandler, are you controlling that? Or who's ever controlling that? Can we start at the beginning there? I can't see it from here. Okay, great. Now this is for the second DUI, is that right?
No.
This is for the first DUI.
The first DUI, okay, or, right. So this is the one where he hit the tree, correct? Okay. So, okay, respondent arrives at no, keep it there. Don't move it. Take it back to the beginning. Who's controlling that? Okay, I can't.
There we go.
Oh, okay, you guys are. Okay, so is that the time that he arrived at work, 6 a.m.?
Yes, Chair Dudley, that's the time he arrived at work that morning. He arrives at work at 6 a.m.
Okay.
He takes an LAPD car out sometime that morning. And then he's coming back from retrieving his cell phone in Santa Clarita, hits a tree at around
Okay, yeah, but I want to go
9:35.
slower.
Sorry.
So that's okay. We don't have any information that he had been drinking prior to coming to work at 6 a.m.
Well, his blood alcohol is 0.03 when they take it at 1
Right.
p.m. And he does have drugs in his system.
Right.
Generally, if you have a blood alcohol at 0.03 at 1 p.m., you probably consumed alcohol at some point earlier in the day. It's unknown when he consumed it. His statements at the IA were that he had consumed alcohol earlier in the morning. I believe it was somewhere in the neighborhood of 4 a.m.
What?
Neighborhood of 4 a.m.
4 a.m. Okay.
Yes.
And that would be inconsistent with the blood alcohol level at 1 at 0.03, correct?
Well, if he had stopped drinking at about 4 a.m., his blood alcohol could have gone down to 0.03 because it would have continued to lower. There's a formula that LAPD could have applied to determine what his blood alcohol would have been at 9:35.
Okay.
They just did not do so.
Was there any information when he arrived at work at 6 a.m. that anyone made any comments about him being under the influence of alcohol?
There was no indication in the IA investigation that that was
Okay.
done.
So the next thing we have is he allegedly left his cell phone at home.
Yes.
And we're going to assume there's alcohol in his home because he said he consumed some before 4 a.m. So what we know is that after he received his cell phone, this hit and run occurred?
That's
Okay.
our information, yes.
Okay, so the alleged hit and run. And then what is the distance between, okay, let me just start with that alleged hit and run there at 9:38. Oh, no, that's when he arrived at the Arco station. We don't know what time the hit and run
The
happened.
bottom square, the.
Right,
9:55.
it's about 9:35. It's approximately 3 minutes or so before.
Okay,
The Arco station is right around the area of where that tree was.
okay, so let me say that again then. From the distance between the tree that was hit and the Arco station was about a 3-minute drive?
About, yes.
Okay, so then he gets, now if he had left the car where the tree was, would that have created a issue in terms of safety for other drivers?
That would require speculation on the part of the
Okay.
division at this point. It wasn't something that LAPD had looked at in their investigation.
Okay,
It wasn't something that the division looked at in our investigation.
okay.
It was something though that was sustained that it was a hit and run. He was.
Say last part again?
It was sustained as a hit and run as
Okay.
part of the sustained findings in LAPD.
Okay, we'll get back to that
He
in a
was
minute.
charged with that.
I'm
yes.
just trying to take it piece by piece. Okay. Then during that 40-minute encounter, there is some information about him spending some time dealing with the car. And then he drives from the Arco station to the mobile station. And that's about 40 minutes apart?
He spends approximately 40 minutes at that Arco station and then goes to the mobile station, which is also nearby.
Okay, then at the mobile station, tell me about the minor incident with another car.
He pulls into a parking spot at the mobile station. He's there for about a minute or two. This is all on surveillance camera footage. He then pulls out of that parking space and backs into a Kia that has pulled in behind him, causing some minor damage. He does get out of the car. The CHP investigation says that it appears that he has exchanged some information with that driver, but neither LAPD nor CHP did any further investigation to determine if they exchanged like insurance information or something.
Okay. Then so that's when he hits the other vehicle, 1024. Okay, and let's stop it again. So after he's hit the tree, gone to the Arco station, gone to the mobile station and hit the second vehicle, that's when he calls his supervisor.
Yes.
And that's from the mobile station.
Yes.
Okay. Then after that, his car becomes disabled and it's on the side of the road, on the roadway?
It's in the number 1 lane of a roadway.
Okay,
And LASD deputy sees him, is going the opposite direction, makes a U-turn, comes up behind him, determines his car is disabled, blocking traffic, calls CHP.
okay. What information, if any, do you have about the nature of the conversation he had with his supervisor about whether he should proceed, stay there, come into the station? If they discuss the damage to the car at that point, any ideas?
We do not have any information
Okay.
as to that
I think the only
conversation.
thing it was said was to contact CHP for the report.
Oh, I'm sorry. Thank
Say
you,
it
Mr. Min.
It said, the only thing in the IA report, it said for him, the supervisor requested him call CHP to come investigate, to do a traffic report.
Okay, but he doesn't, as far as we know, call CHP. CHP sees the car in the roadway?
They are notified by LASD.
Okay, so I'm assuming then the supervisor or somebody notified CHP.
No, LASD notifies
There was nothing
CHP.
stated
Oh.
that anyone from LAPD.
All right. And then you're right. I may have been confused about this. At some point, was the respondent asked about the tree incident?
He was asked what he hit and where the accident occurred. The CHP, where it appears from the CHP investigation that he was asked that. But it's not very clear in the CHP investigation at what point that question happened. What is in the investigation is that the CHP officer who was conducting the investigation made some assumptions that he thought the accident may have occurred in a couple of locations. And so he took the respondent to two different locations that involved a pole that had been hit. Mr. Thompson was able to categorically tell the CHP officer, no, that was not what I hit. That's not where the accident occurred. They then took Mr. Thompson to a hospital to get him medically cleared and then cited and released him.
Go back to that. I want to understand this a little more. The respondent has some discussion with the investigating CHP officer. And as a result of that discussion, they go to three places.
Two different places at this point, yes.
Two different, and then is it the second or the third place that ends up being the tree?
It ends up being a fourth place. So they go with
Okay.
two places with Mr. Thompson. Mr. Thompson's able to exclude both places. They then take Mr. Thompson to a hospital to get him medically cleared, since he's been in an accident and he's under the influence. It also appears they take the blood sample at that time.
So we have no idea what led the CHP officer to take Mr. Thompson to place one or place two.
The CHP officer states in his report that he believes, based on damages he'd seen from the poles, that he suspects those may have been where the accidents were. So they're basing it off of the damage to the car and where he's seen damage to objects that look like they could have caused the damage to the vehicle.
So just so I can stand this better, there's some discussion prior to going to place one and place two that it was a pole versus a tree.
It's not
And if you don't know,
clear,
that's fine.
right, it's not clear how the CHP drew that conclusion,
Okay,
but that's what they did.
I
from
believe
their
there was
report.
damage at those locations.
Right.
So he naturally thought, okay, there's damage, we're gonna go to that location. Then after that, he goes back and he's able to determine that those other locations were prior accidents and not this vehicle. And then he locates the other location of the actual accident.
okay, so why this is interesting to me is if we're looking at dishonesty as one of the issues here, I don't know, the board doesn't know whether it was as a result of dishonesty that they ended up at those two prior locations and even the third location, and then it wasn't until the fourth. So that's where there's some confusion. I'm not even sure we can answer that question at this point. Okay,
That was in the CHP report, what they specifically asked him or
right,
what he answered.
okay.
Besides that's not it. When they rolled up and he gave the answer that this is not the location, it's further down. Those are the only statements that they wrote in the report.
Okay. So then am I also to understand that both the second, we'll call it, we don't know about the prior alcohol related offense. So the first DUI and the second DUI both had to do with the hit and run issues, right?
No, the second DUI, he stayed at the scene. His vehicle, which was his personal vehicle, ran out of gas and he was pushing it to get to a gas station. And he got away from him. It hit a pole in front of some Southern Cal Edison
And he
employees.
stayed there.
And he stayed at the scene.
Okay, so as to the first DUI, the arrest was made, including the DUI and the hit and run, and did the district attorney's office not proceed on the hit and run?
No, they did charge him with the hit and run, but the plea deal was just a DUI, a straight DUI under subdivision A.
Okay, those are my questions. That, by the way, again, thank you for this timeline. Other questions from the board?
Yes.
Yes.
So these are for Brad. Is it clear? I believe it's clear.
So would you move the mic a little closer?
Forgive me.
Thanks.
It appears clear to me, but I want to ask you as the investigator, did Mr. Thompson have the ability after the first collision to immediately notify a supervisor?
It's not clear exactly what his condition was. we're assuming that based on his alcohol content that he wasn't making rash decisions on that, and he didn't make it. I don't know if we couldn't figure out if he was trying to see if he could fix the car enough where he could get away, but it was obviously that the car was not in that condition. So he could have.
Or is your question whether he had a phone?
Yes.
Yes,
Oh,
that's what I thought.
yeah, sorry.
So he's not talking about his mental state. He's merely saying, did he physically have a phone
Yes,
in
he had
order
a
to
phone,
do it?
because he called later on.
And because the point of my question is one of you're in a hole and you have the ability to stop digging, then you should probably do so. If he had the means immediately at his disposal, rather than attempting to repair his vehicle and move and then ultimately cause yet another collision at another scene and imperil people further, I wanted to see if there was some way at that point he could stop digging. And your answer is yes, he had the means.
He had a phone.
Thank you.
Thank you. Other questions? Yes.
I just wanted clarification. I saw somewhere, and I think it was in the court notes, that on the 17th was a wet reckless, the 14th was DUI, no contest, and an admission of a previous DUI. So that had to have been in the 1990.
No, that's not how they did it. What they did was they had him admit to, I'm going to get this wrong. They had him admit to the March 17th incident first. It was part of the plea deal. So what they did was they had him admit to the March 17th deal first, and then the March 14th deal second. And then because the admission for the March 17th deal came in first, it became a prior conviction that he then had to admit for the March 14th one. So they did.
But
kind
that
of
was a
legal
wet reckless. That was not a DUI.
But that can be a prior conviction for a DUI. A
Okay.
wet reckless can be,
Okay.
yes.
Can we go back to the timeline again? What I'm looking for here is we can extrapolate what his blood alcohol level was at the time of the first, let's go to, move it over more to the left, if you would, please. Guys, I want to see, yeah, thank you. And then if you can close in, do a close-up, thank you. So at approximately 9:38, he arrived at the ARCO station. We said it was 3 minutes away. So 9:35 a.m. would have been about the time that he hit the tree. And the blood alcohol of 0.03, was that based on blood or breath?
That was a breathalyzer test.
I'm
at the
sorry?
time. That was a breathalyzer test.
Okay, and the breathalyzer, how much time went by between 9:35 and the blood and the PAS device?
It's 3.5 hours.
Okay, so regardless of when he started the drinking, can you give the board a sense of what his blood alcohol level was at the time, 9:35, assuming he had nothing alcoholic to drink between 9:35 and the PAS device?
There is a formula that the DMV has as part of the driver's manual. However, the application of that formula really does require special training, which none of us have. That would be something, if this went to hearing, we would hire an expert, employ an expert to present at trial as part of the evidence. To say, whether or not Mr. Thompson was over the legal limit at the time he had his accident. So at this time, we would not be in the position to opine what his blood alcohol would have been at.
Okay, fair enough. And then the blood sample, what was that result?
We do not have the blood sample, but we do know because the DA, the Los Angeles District Attorney's Office, charged him with the G count of 23152, that he would have had some form of a drug in his system as well. Because in order for the DA to be able to charge him with that, he had to have had alcohol plus a drug in his system.
Okay, so allegedly he took the Ambien
Yes.
the night before and had a prescription for that. Do we know if the blood test, if it showed the percentage of the drug Ambien?
It probably did, but we do not have that information.
Okay. Thank you.
You're welcome.
Other questions from other hearing officers?
Hi,
Please.
counsel. For clarification, the wet and reckless law is not really familiar to many. I have a little bit a knowledge of it. Could you give us a little bit of summary about the wet and reckless law and why it was applied? And to my second question of the wet and reckless law, from my understanding in that, in the first arrest, which was March 14th, if I'm correct, March 14th, and then he had a second incident, March 17th, but the wet and reckless was applied to the March 17th, not the
Yes.
March 14th. That was
Yes.
my confusion. And, go
It
ahead.
will make more sense when I explain what wet and reckless means.
Okay,
So
thank you.
wet and reckless is something that's available to prosecutors as a plea deal, essentially. So a prosecutor has some discretion to offer a wet and reckless to those defendants who are close to the legal limit. So on the March 17th incident, Mr. Thompson was at a 0.08, 0.09. So he was close to the legal limit. As far as we know, he only had alcohol in his system. So the prosecutor had the discretion to offer what's known as a wet and reckless, which means you had alcohol in your system and you were driving and you engaged in conduct that ended up being reckless on the streets, because by definition, if you're driving with any alcohol in your system, you are in fact reckless under the law. So that's what wet and reckless means. And it ends up being a driving under the influence of alcohol conviction on your record for purposes of like prior convictions for DUI, that sort of thing. So that's where that comes in. And Chair Dudley can correct me if I'm wrong about any of this, and she's got such a history of being a lot of experience, obviously, as being a district attorney. For the March 14th incident, however, that probably was not available to the district attorney, or just wasn't something the district attorney would have been interested in offering because of that drug that was in Mr. Thompson's system. And under that one, the G count, if you have any alcohol in your system and you have a drug, it's a DUI, just full stop under G. So if you've got something that's a controlled substance such as Ambien, Xanax would be another one that's common. People will get some alcohol in their system and have something like a Xanax. It's a DUI. It's a full-on DUI misdemeanor under G. And frequently, it's not uncommon for a district attorney to not offer wet and reckless in that situation because you're so impaired at that point for driving.
It's on a wet and reckless because of the accidents, and this is where I was kind of confused on, is both of them involved accidents. 14th and
I did.
they both involve that. And the district attorney has a discretion to apply.
Yes.
Now, his next question is, on a wet and reckless, because to me, it sounded like it was a DUI. And because I'm not familiar with either or, but what is the purpose of even offering the wet and reckless? I mean, is the penalty different or less?
Yes.
Or say, I mean,
The fines and fees for a wet reckless are significantly less. There's less jail time, I believe, but I'd have to check. There may in fact not be a mandatory jail sentence for a wet reckless. The DUI program is usually less for a wet reckless for the first offender. Since he had 2 in a row, that's how he got the 18-month program. And he also had a drug in his system, which is probably also why the 18-month was imposed. So there are significantly less penalties imposed for somebody with a wet reckless. So that's one of the reasons why it gets offered in those sorts of cases and why defendants will take that. Even though there's the consequence of it being a prior conviction if you get a second.
so the wet and reckless is not really held as high as regard compared to the DUI, but he was offered it. That's
For criminal penalties, yes, but on your driver's record, it's going to have a similar effect, is my understanding. Yes,
you.
you're welcome.
Any other questions or comments? Yes, Dr. Blazer.
Thank you. One question, there was some contradiction or inconsistencies among the various different documents that we reviewed about when he was on duty and when he was off duty. And I just wanted to get clarification. I think he was on duty on the 14th and off duty on the 17th. No?
There was some contradiction in the records. So LAPD initially said in their IA documents, he was off duty on the 17th. That's incorrect. He was actually on duty on the 17th as well, but he was on what they call home duty. So a lot of agencies will call it like administrative leave. He was sent home, but he was supposed to be on duty. He was just at home. So he wasn't coming into the office. He wouldn't be like what they would consider active. There is a follow-up memorandum in his IA investigation that said he had to report in. I think he had a meeting with another department. He had just finished at that point, right before he left to go get food and then ended up in the accident. So he was on duty.
And then on the 17th,
Let me just respond to that a little
Oh.
further. So even though he was at home, the concept of being on duty relates to the fact that they could call him in, and therefore could call him in, and being at that blood alcohol level is part of this whole scenario.
Correct. Yes.
and on the 17th, there was also an indication that he had a nearly empty open container in his vehicle. And I was just wanting to know if we could get some clarification on how nearly empty, but also an open container that's empty is problematic anyway.
Right. The police report from Los Angeles Sheriff's Department indicated there was an open vodka container in his vehicle that was nearly empty. Yes.
Thank you. Any other questions? Yes.
Johnson, I had heard you mention something about dishonesty and you didn't go into the details of that. Then board member Charles talked about at some point, when do you stop digging a hole for yourself?
I'm sorry, could you move the mic closer?
Yes.
Thank you.
And board member Charles spoke about at some point, when do you stop digging a hole for yourself? So we do know that he lied to the officer in the first incident that he wasn't drinking. 3 days later, he got pulled over. He lied to that officer that he wasn't drinking. I mean, it's obvious that the facts show that he was under the influence. At some point, it's troubling that an officer consistently try to fabricate a situation that he's in. Now he has signed a document that I believe is supposed to save his job. And so we're here gathered today to discuss on whether to decertify him. Even though he has signed this document, is there a conflict with that?
The civil settlement that he filed with LAPD is separate from these proceedings. Post has independent jurisdiction as to Mr. Thompson's certification. So there's no conflict. Post can proceed separate from any actions that LAPD chose to take.
So he can still be decertified,
Yes,
even though he made an agreement with LAPD that if I do this, 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 and that, can I keep my job?
absolutely. Yes.
So now, I guess I'm jumping ahead. How would the administrative judge look at it?
The administrative judge would give it the weight that they felt was appropriate. So they could take it and decide it had no weight. They could take it and decide that it should be given great weight. One of the things that they would be looking at is the terms that Mr. Thompson had agreed to. So the terms that he had agreed, the agency had proven. It would just depend upon the administrative law judge. But again, these proceedings are entirely independent. So Post's position would be that it really does not have much weight since the agency acts independently from Post.
And I
Thank you.
guess the last follow-up question, I think it's been a history that Post normally would grant the right for that officer to continue on his job if he signs up on an agreement. So even though we may feel he should be decertified, because of the history that has been established, that most officers that sign an agreement to stay on the job, if they follow this, and this, normally is granted that at the Post level. So I'm trying to see if we could break that cycle. But anyhow, yes, I'm listening to figure this out.
The board will make its recommendation and it'll go to the commission, who will be able to either adopt the recommendation or do what the commission wants to do. This particular case is a bit different than the other DUI cases we've taken. As everybody's pointed out, these particular DUIs did happen on duty. There was some concealing conduct. We don't know how the commission's going to respond to this particular case, but the board does make its own recommendation.
Board Member Johnson, I think it's productive just to remind ourselves of sort of the grounding trajectory that we're supposed to be taking as a board, and it's, 13.510.85, right? Which is to say, basically, does the investigation, summary of findings, and the recommendation by the division, does that justify decertification under the board's perspectives? And so, not getting outside the four squares of what we have in the investigation, and based on the presentation, I think we should really be guided by those perspectives.
And I'd like to call upon our Assistant Executive Director for some comments.
Thank you, Board Member Johnson, for the questions. I'd like to speak to all of them if I can. In terms of the settlement agreement that the respondent signed, he subsequently retired from Los Angeles Police Department on August 31st, 2024. He's not currently working. Second, apart from that, you asked about ALJ weighing the employment agreement versus the certification status. That would be the interest of the state. My experience with administrative law judges, what they are looking at is, does this individual pose a threat to the public health, safety, and welfare through his inability to make choices that pose an immediate threat? In this situation, the employment status in the agreement, what the judge would be looking at is any rehabilitative efforts on the part of the individual to prevent this from happening again. And the respondent would have to demonstrate that he no longer poses this threat. And it would be difficult for us to assess whether or not he can make those claims at this point. The employment status is not what's considered, if you will, from the administrative law judge. It's whether or not this individual still poses a threat because of behaviors and judgments and decisions made that's brought this case before us today. In terms of making a decision on a stipulated settlement, I think you've talked about in previous DUI cases, it's not post that's making the decision. The commission itself can make the decision to enter into a stipulated settlement. Again, those are not perfunctory. They do not happen in every case, and they have to examine the very specific circumstances of each and every case to determine whether the public would be well served by entering into an agreement with the individual who has overcome whatever those issues are and has proven for a period of time that they can, in fact, engage in the professional conduct of a peace officer safely, effectively, and without issue of controlled substances in their system. So it is not automatic, it is not perfunctory, and the commission would have to weigh those very same things in this case and make the determination that they do not believe that the public would be at risk by allowing this individual to return to the profession.
Thank you. You're welcome. We're going to need a break, but I want to say, are there any other questions for, yes, please. Ms. Pena.
How long of a delay was there between the time he encountered, I guess it was CHP that came on the scene, and when he was actually tested? It was a lengthy period of time, correct?
CHP got on the scene at around 11:05, and he doesn't take the alcohol screening test until 1 o'clock, a little after 1 o'clock. So yes, it takes them some time.
Is that typical?
I wouldn't be able to answer that question. I think each investigation's unique. It probably depends upon the facts and circumstances.
Anything else? Any other questions? Yes.
So, Johnson, he has retired in August. I don't want to say what bearing would it have with the agreement that he's made? To me, it becomes a moot point. I mean, because he's no longer employed by the LA Police Department. So I guess I'm saying that being that there was an egregious act and a violation of law, it should be pretty simple. It's like him not appealing the issue. So there should not be no reason, I believe, for him to be so much concerned with whether he's certified or decertified. He's no longer a police agent, a police officer in the state of California anyway. So this should be an easy fix by simply decertifying for the egregious act that the division, as well as the agency, saw that he had acted in.
Mr. Thompson's available by phone. I believe he would be able to answer that question best.
We will, anything else for now? Otherwise, we'll take a 10-minute break and then come back and ask if Mr. Thompson or his attorney has any comments for us. Okay, so the time is now 10:21. If you could come back at 10:30. At this time, does the subject officer and/or their counsel wish to make public comment? If so, you will each be given 4 minutes to speak, and the time limits will be strictly enforced. So please ensure that you are complete your comments within the allotted time. There will be a clock on the screen that'll start counting down from 3 minutes. Because the discussion this morning was so lengthy, I'm going to extend it at my discretion to 4 minutes to ensure that each of you get to say what you want to say. So while commenting, keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defense at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do these facts demonstrate a high probability that serious misconduct, as defined by Penal Code Section 13510.8 and Commission Regulation 1205 occurred? So, is there anyone from the public who would like to address the board at this time? When it is your turn, you may state your name and the organization you wish, and we will limit it to 3 to 4 minutes, depending who you are in terms of this case. And as I said, it's generally 3 minutes, but leaving additional time for the respondent and his counsel. For the time limits will be strictly enforced, so please ensure you complete your comments within the allotted time. So, is there anyone here on this case? Remote or in person?
Ma'am, I'm the officer involved in this incident. Can you hear me?
Is this Mr. Thompson?
Yes, ma'am.
Yes, we can hear you.
Okay.
Please go on.
I'm sorry. If I could, I'd like to just summarize a couple things.
Sure.
First and foremost, I want to thank the board for giving me the opportunity to speak and kind of maybe hopefully clear some things up if needed. I understand why the board needs to convene on this matter and what's led for us to be here today. And I just a brief summary. I'm a 28-year veteran with LAPD. I was hired in 1996. I've worked in South LA for all but one year of that. I've been one of the highest, if not the highest, producers in all areas of work. I received hundreds of accommodations for productivity. I patrolled areas troubled by gang violence, and I've made hundreds of observational felony arrests, including minigun arrests of armed gang members. I've received a Master 10851 award from CHP, all of which were occupied stolen vehicles, several of them being used for the purpose of drive-by shootings. I always wanted to be a detective and started started in it, working the due diligence unit, which finds suspects of 187 of homicides that have warrants. I then linked into being an investigator, and within a few years, received a Detective of the Year from my division, and also Detective of the Bureau for Central Bureau in Los Angeles. I received several several citations from the mayor for my clearance of homicides, and I've been involved in arresting and convicting hundreds of homicide suspects. I promoted to supervisor, and I received, as you know, have a supervisor post certificate. I was on call for several years working homicides, and it took its toll. It all came to a head in March 14th and 17th where these incidents occurred. I did understand that that the development of alcoholism, and I checked myself into Betty Ford, and I'm still in. I go to AA meetings, and I'm still in the DUI program with the state. I have a sponsor. I have a very good support system. My partner, who I live with, she's a Superior Court judge with the state of California. I've been with her for 13 years. My mother, who's been sober for over 40 years. I have two children, Isabella and Shay. Bella is finished her college and is pursuing her law degree. My younger child is in her third year of college. I'm very proud of the badge that I wore, and I'm sad that I tarnished it. I did retire from the department. I did so after I did my suspension days because I wanted to retire honorably. And during this process and working so long, over 20 years as a homicide investigator, took its toll, which led into to the events that happened in these 2 days. I developed a sleep disorder because of the hours that I worked. I worked several days straight, and that's why I was prescribed Ambien. I did and do acknowledge that I am an alcoholic. I have quit drinking since, and continue with my efforts to remain sober. And again, I have a very good support system that assures that I am. In conclusion, if the board needs any clarification on any of the matters, I'd be happy to speak on that.
Okay, let me just, on behalf of the board, thank you for your years of public service. Thank you for calling us. Clearly, you do have a distinguished career, and to extend our understanding and appreciation of the actions you've taken to deal with your alcoholism. So aside from that, I'll see if the board has any other comments or questions.
Board Member Clavo, are you attending AA? Do you have a sponsor? What are you doing?
Yes, I do go to several AA meetings a week, and I do have a sponsor.
How long have you been sober?
Since this incident.
Thank you.
Anything else? Okay. Mr. Thompson, are you being represented by counsel? Are you here by yourself today on the phone?
I'm here by myself now.
Okay. I think there are no other questions. Is there anyone from the public who would like to address this matter? Anybody on the phone? Anybody here with us? Okay. None, and hearing none. Mr. Thompson, thank you for calling in, and we wish you the best.
Thank you, ma'am.
Okay. So, at this time, we can adjourn into closed session and discuss this case. Ready? Where are we going today? This way or that way? Okay, Mr. Chandler is going to show us where to go. Thank you. Okay, we'll be back. This meeting will adjourn into closed session for deliberation on this case. The board members will now exit the room and be back for regular session shortly. Everybody ready? Okay, we'll now reconvene to regular session to take a vote on the board's recommendation in the matter of case post number 2400920, Tommy Thompson, who at the time of the events at issue in this case was employed with the Los Angeles Police Department. What comments does the board have on this matter? Please, Dr. Glazer.
Oh, I'm ready to make a motion unless there are people who want to make comments prior to that.
I'm sorry, I couldn't hear you.
I'm ready to make a motion unless there are people who want to make comments prior to
Does
that.
anybody want to make any comments before a motion is called? Okay, go ahead. Is there a motion? Is there a motion to make a recommendation to the commission on this matter?
Yes.
Okay, what is that motion?
I move that we recommend to the commission that Mr. Thompson's certification be revoked and that revocation be stayed contingent on a settlement agreement between Mr. Thompson and Post that would suspend that would put him in a period of probation of 10 years, during which he would have to submit to the standard agreement that we've seen unfold in the past, and I defer to counsel to provide any further detail on that, but I have no pride of memory on that matter. And that should he violate the terms of that settlement during that period, that there would be automatic revocation.
Okay, thank you. Is there a second?
I second.
Okay, the second was
Margaret Pena.
Ms. Pena? Okay. Okay, now, Mr. Wall, if you would call for a roll call vote on that?
Yes, Madam Chair, thank you. Clavo,
Hey.
Clavo, nay. Crawford,
Aye.
Crawford, aye. Doyle,
No.
Doyle, nay. Dudley,
No.
Dudley, nay. Glazer,
Aye.
Glazer, aye. Johnson,
Hey.
Johnson, nay. Lara,
Nay.
Lara, nay. And Pena.
Aye.
Motion fails.
I'm sorry, motion failed. Okay, and the numbers for the record?
We had 3 yeses and 5 noes.
Okay. That motion failed. Is there another motion?
Certify?
Doyle made a motion to decertify. Is there a second?
I second.
Okay, Laura seconded. Would you please call roll call on that?
Yes. Clavo,
Yay.
Clavo, aye. Crawford,
Oh.
Crawford, nay. Doyle,
Yes.
Doyle, aye. Dudley,
Yes.
Dudley, aye. Glazer,
Aye.
Glazer, aye. Johnson,
Aye.
Johnson, aye. Lara,
Aye.
Lara, aye. Pena,
Aye.
Pena, aye. Motion carries.
Okay, that motion, so there was not a unanimous motion. There were in fact 3 negatives, but there were 5 positives. So that motion does in fact pass. Okay, no?
Everyone else agreed?
There's only one no.
Oh, I'm sorry. Okay, so on the second vote?
Madam Chair, for the record, that motion carried with 7 yeses and 2 nos.
Okay, 7 and 2. All right, thank you very much. Thanks for clarifying that.
There's only 8 of us here. How could it be 7?
I couldn't hear you. Sorry.
This 7.
Sorry.
It's one of those.
I got 2
7
votes.
ayes, 1 nay vote.
Yeah,
For the record,
I can't hear you.
for the record, I meant to say his thing, but I said no, but
She meant to say abstain.
Okay. You know, this has gotten a little too confusing for the record, so we're going to do that one again. Okay. I want to make sure everybody votes what they want to vote.
I think that's a good.
So there was a motion to decertify, and that was made by Doyle, and that was seconded by Laura. So let me ask you again, would you please take that vote?
Yes, Madam Chair.
No, not your fault.
Clavo,
Yes.
Clavo, aye. Crawford,
Dang.
Crawford abstain. Doyle,
Yes.
Doyle, aye. Dudley,
Yes.
Dudley, aye. Glazer,
Aye.
Glazer, aye. Johnson,
Yes.
Johnson, aye. Laura,
Aye.
Laura, aye. Pena,
Aye.
Pena, aye.
Now, would you give us the final record on that, please?
We have 7 ayes and 1 abstention.
There were no no's.
No.
Okay. Okay, moving on to the next case, and again, we will break at noon. At this time, I will call upon law enforcement consultant Robert Bringolf, professional conduct, Los Angeles County Bureau, and Carrie Woolley, attorney, legal affairs bureau, to provide a report on case post 2302971, Gabriel Gazolia, who at the time of the events at issue in this case was employed by the Los Angeles Police Department. Please.
All right. Good morning, everybody. My name is Robert Bringolf. I'm one of the law enforcement consultants assigned to the Professional Conduct Bureau for Los Angeles County. With me today is Carrie Woolley, an attorney with our Legal Affairs Bureau. I'm here to present case 232971 involving LAPD Sergeant Gabriel Gaxiola. It's the division's determination that clear and convincing evidence exists to demonstrate that Sergeant Gaxiola committed an act of serious misconduct as set forth in Penal Code Section 13510.8, being arrested while off duty for driving under the influence of alcohol on May 13th, 2022. Specifically, the division has determined that Sergeant Gaxiola committed the following acts of serious misconduct. That would be acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with the peace officer's obligation to uphold the law or respect the rights of member of the public as determined by the commission. And that's Penal Code Section 13510.8, B as in boy, sub 6. So this morning, I'm going to present a brief outline of the division's findings of my investigation in this matter. Sergeant Gaxiola was hired by LAPD on October 26, 1998. He was promoted to sergeant July 7th, 2019. On May 13th, 2022, Sergeant Gaxiola was arrested for his second DUI while employed as a peace officer for the Los Angeles Police Department. He was off duty and driving his personal vehicle on State Route 110 in the area of North Avenue 52 overpass. His vehicle collided with a stopped vehicle, which in turn collided with another vehicle that had been stopped in the number 3 lane of traffic. Just so everybody's on the same page, the lanes are numbered from the inside of the roadway to the outside, 1, 2, 3. Gaxiola immediately contacted emergency services, which resulted in the California Highway Patrol responding to the scene. The CHP officer observed Sergeant Gaxiola had red, watery eyes, an odor of alcoholic beverages emitting from his breath and person. He had an unsteady gait, and that was observed while he was walking around the accident scene. He had slurred and delayed speech, and when one of the officers asked for his insurance card, he handed him his debit card instead. A CHP officer conducted a standard field sobriety test and determined Mr. Gaxiola had been driving while under the influence of alcohol. He was arrested for driving under the influence in violation of 23152 sub A VC. It's the vehicle code. Sergeant Gaxiola refused to submit to a chemical test, at which time a search warrant was sought for a sample of his blood. The warrant was granted and executed on May 14th, 2022 at 01:22 hours. That's approximately 5 hours after the accident occurred. And he was also arrested for section 23152B of the vehicle code. On May 17th of that same year, 2022, the lab report came back and showed that the analysis of the blood sample from Mr. Gaxiola resulted in an average of 0.155% blood alcohol concentration. or BAC, as you might hear me say. The legal limit is 0.08 BAC. An LAPD subject matter expert later calculated that an average male of Gaxiola's build would have had an approximate BAC of 0.23 5 hours prior to the collection of that 155 sample. As an aggravating factor, Sergeant Gaxiola was found to be carrying his handgun in his waistband at the time of his arrest while he was driving intoxicated. On February 9th, 2024, Sergeant Gaxiola pled no contest to and was convicted of one misdemeanor count of driving under the influence of alcohol with a BAC of over 0.08%. That's a violation of California Vehicle Code Section 23152B. During that same proceeding, Sergeant Gaxiola admitted to a prior conviction for driving under the influence in Los Angeles County Superior Court. That's related to a 2016 case or arrest, case 16HM08811, and that's from January of 2017. On February 9th, 2024, Mr. Gaxiola was placed on summary probation for a period of 60 months. The conditions of that probation are that he not operate a motor vehicle with any measurable amount of alcohol in his blood. He's not to drive a motor vehicle without a valid driver's license in his possession or without liability insurance in the minimum amounts required by law. He's to comply if ordered by Department of Motor Vehicles to install an ignition interlock device as a condition of probation. He's ordered to make restitution to the victim per Penal Code Section 1202.4 small f in an amount determined at the hearing. He's to pay a probation revocation restitution fine pursuant to Penal Code Section 1202.44, which might be enforced in the manner provided for the enforcement of money judgment in the amount of $150. He's to obey all laws and orders of the court. He was also ordered to serve 4 days in city jail as a condition of his probation and to pay a fine of $500 plus penalty assessments, and enroll within 21 days from the date of his court hearing or his release from custody and successfully complete an approved licensed 18-month driving under the influence program, as well as enroll in and complete a MADD victim impact program and attend 52 Alcoholics or Narcotics Anonymous meetings at a rate of 2 per week. In addition to those court proceedings, on January 26, 2024, Gaxiola signed a rehabilitation agreement with the LAPD in relation to the second DUI case. In that agreement, he admitted he engaged in misconduct that warranted discipline, and he agreed he understood the Board of Rights was agreeing to hold his discipline in abeyance until he completed the terms of his rehabilitation agreement. The division has also examined and considered his first DUI arrest as a peace officer, and that case was considered pursuant to California Code of Regulations, Title 11, Section 1213. Brief summary of that: on July 10th, 2016, around 02 hours, Sergeant Gaxiola, then Officer Gaxiola, was off duty in the city of Laguna Beach, California. He was driving his assigned police vehicle. He'd been assigned to the SWAT team at the time of this event, and he had taken his city vehicle to a wedding in Huntington Beach, California. At the wedding, he'd consumed mixed drinks, but didn't know how many. After leaving the wedding in his city vehicle, he was stopped for a traffic violation by an on-duty Laguna Beach police officer. During that traffic stop, he displayed objective signs of alcohol intoxication and was given a horizontal gaze nystagmus test and was arrested for a violation of Section 23152A VC, which is driving under the influence, and it's a misdemeanor. After his arrest, he refused to submit to a preliminary alcohol screening test, but did submit to a blood test. He was found to have a blood alcohol content, or BAC, of 0.202%. To further aggravate that situation, his city-owned vehicle had to be towed to Laguna Beach Police Department and secured in their Sally Port, as the vehicle contained department-issued equipment and weapons. And while that victim was being secured, officers located an open bottle of beer in the front passenger compartment. He ultimately received a 22-day suspension without pay for that 2016 DUI arrest. And in 2017, he received a misdemeanor conviction for violation of Section 23152B. The charge of 23152A was dismissed, And he received 3 years of informal probation, $140 fine, a mandated 6-month first offenders program, and some victim impact counseling. So the facts as I've just recited support the division's finding that Mr. Gaxiola was involved in serious misconduct, specifically acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law. For purpose of our findings at the division, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Sergeant Gaxiola's post certifications be revoked, and the division's recommendation is based on the following. He had been arrested for violating the law on 2 occasions during his employment as a peace officer. More specifically, both arrests have occurred while Sergeant Gaxiola has held the rank of sergeant. While a repeated violation of the law alone may not always rise to the level of serious misconduct, it's the nature of these arrests and the aggravating factors that led the division to find clear and convincing evidence exists to prove he'd been involved in serious misconduct, specifically that described in 13510.8 sub B sub 6 and California Regulation 1205 sub A sub 6. The public has a right to expect high moral and ethical standards from the police, and Sergeant Gaxiola's wanton disregard for public safety on more than one occasion merits decertification. Further, the public has the right to be policed by individuals who are held to a higher standard. Sergeant Gaxiola's actions and arrests do not meet this standard. Sergeant Gaxiola's blood alcohol concentration at each arrest was remarkably high. Expert opinion indicated that at the time of Gaxiola's recent accident, his blood alcohol content was likely around 0.23%, which is approximately 3 times the legal limit. Evidence from Gaxiola's previous arrest for driving under the influence of alcohol showed his blood alcohol at the time of the sample was 0.202 and then 0.200. For his part in these arrests and incidents, Gaxiola put numerous lives in jeopardy on at least 2 occasions. Once in a city vehicle filled with his SWAT gear and weapons, and once in his personal vehicle while armed off-duty. The latter of the 2 resulted in a vehicle accident which caused damage to Gaxiola's vehicle and 2 additional vehicles. For these reasons, the division finds the repeat offenses particularly egregious. With that, I'm happy to try and answer any questions that you as the board may have.
What was the first DUI?
So the question was, when was the first DUI?
Yeah, because you said something about 2016 and then you said 17. Was 17 the plea or when did the event occur?
Yes, ma'am. Good question. 17 was the plea. 16 was the arrest. July 10th, 2016 at 2:07 in the morning was the stop.
Okay, a couple more questions
Yes,
about that.
Okay.
Do you have any information as to why he took a city vehicle to the wedding?
I don't have any information and it would just be supposition on my part. I can tell you that he's, as a SWAT team member, he's likely on call. Though why he would drink on call is beyond me, so.
The other question is, thank you for your description of, on the 5/17/22, that the assessment is at the time of the driving, he was at a 0.23. Can you tell me about the time discrepancy and what the time would have been at the driving of the 2016 event where he got a 0.2?
That was an on-view arrest. And I don't know how long it took for him to get a blood test.
Okay, so there
But-
was some time between the time that he was driving and the time that he got a blood test, but we don't know how much time.
Yeah, and I don't know that it's necessarily remarkable outside of other DUI arrests. On the second DUI, it was remarkable in the sense that they had to seek a search warrant and then that protracted the amount of time. But in the first arrest, there was no indication that there was a protracted amount of time that would have been abnormal for a
Okay, but
DUI.
generally blood tests are not done in the field.
Blood tests generally are not done in the
Did you
field.
say this was a blood
blood
test?
alcohol test, it's sort of a misnomer.
Okay.
It's testing one's blood alcohol concentration. It
right.
can be done by drawing blood
Right.
or by taking a breath sample.
In 2016.
I don't know.
Okay.
Yeah.
So we don't know whether it was a breath, blood, or urine test. We just know that there was when it was tested, it ended up being a 0.2.
I believe it's in the record and I can look at it. Did you have that answer, Karen?
It's a blood test
Okay,
in
there you go.
I
2016.
thought it was blood tests. And so generally, again, blood tests are not done in the field.
Blood tests
So
are
some time goes by between the
typically
time.
not done in the field, yeah.
Okay.
I mean, I don't want to say never, but.
Okay, no, I definitely, there's some jurisdictions where ambulances roll out, but in general, okay. All right, those are my specific questions. Members of the board, questions? Yes.
So this is for the investigator. The second collision, when he was a supervisor, he collided with another citizen's vehicle. I want to make sure I'm clear about that.
That's right. My understanding of the accident, I believe there's a diagram in the attachments that you received, the accident diagram. My understanding is he's coming around a corner on an off ramp, and there were two vehicles that were disabled on the side of that off ramp or exit way from the highway, and he collided with the rear of the vehicle in the back of that two vehicle.
Which then collided with the one in front.
Yes, ma'am. And then that
Okay.
moved it forward and
Okay.
collided with the rear of the vehicle in front.
Thank you.
Does that help, Captain? Are you-
Very much so. Thank you.
Okay.
Yes, Dr. Glazer.
Hi, thank you. A couple of questions. One is, on his record of disciplinary action within the department, there are 3 cases of discourtesy, and there's an indication on all of them that they were not resolved. And I'm wondering if we can get some clarification on what that means.
We may be able to, but not from me, and that wasn't included in the record specifically. So those cases were when we ask for previous work history and any discipline history. Sometimes these things are pretty old, and they may not have those. In this case, I don't remember specifically, but I didn't find that it was necessarily probative to the DUI, and so I didn't look into it anymore.
Okay.
Yeah, the discourtesy didn't necessarily lend me to think the DUI was.
We
more
don't have a
probable.
clear sense of what LAPD means when they say not resolved.
No, and I also, again, I don't want to speak for LAPD. I have an idea that maybe I can tell you in general terms that there are instances where they can't get a hold of the complainant a second time. Sometimes the complainant decides they don't want to do anything. Sometimes they handle it administratively because maybe it wasn't necessarily outside of their policy, but it needed to be addressed if somebody was rude. But so it's really hard to say, but again, it wasn't necessarily important to the DUI part of this.
Then I have a question that's probably for counsel for Christopher Beatty. And that's, we're supposed to be making determinations here based on egregiousness and repetition. And I'm just wondering how we treat the 2016 offense when it predates the law.
So let me
Predates
just
the-
interrupt for a second. I think the standard is either or. I
Yeah,
don't think it's,
yeah.
okay.
But whichever we're thinking about,
Yeah.
if we're thinking about repeated, are we allowed to consider 2016, which predates the period that the law covers?
I think it's appropriate for consideration, but it can be a factor of how much weight that the board members want to give it. In other words, there's both the passage of time and then sort of the jurisdictional limit there that the board can factor into its calculation. Board members can factor into their individual calculations and give that the weight that the individual. So I don't want to dodge the question, but I think it's appropriate to consider those factors. Is that helpful?
And from the division standpoint, we just brought this in because it's evidence of prior conduct that's similar to the evidence that's brought before you today.
Just for information, typically not resolved means the complaint can't be proved or disproved.
That would be consistent with my experience as well as an agency attorney, yes.
Any other comments or questions from hearing board members? Thank you very much. Let's see. At this point, the subject officer and/or their counsel wish to make a public comment? Okay, if so, you will each be given 4 minutes to speak and time limits will be strictly enforced. Please sit down. So please ensure that you complete your comments within the allotted time while commenting. Keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? Please.
Thank you. Good morning, still. I wanted to point out just a couple of things. I believe that, oh, I'm sorry, Leslie Wilcox, WILCOX. I'm a union attorney for the Los Angeles Police Protective League.
Would you mind also moving the mic a little closer? Thank you. Welcome and please go on.
Do you need me to repeat any of that?
Yes, thank you.
Okay. I'm a union attorney for the Los Angeles Police Protective League, and I represent Sergeant Gaxiola for this particular post-hearing. He was planning on being here today remotely, but he's been assigned to the Palisade fires for the next few days, which is, as I'm sure you all know, something that's happening regularly with LAPD. He is back at work as a sergeant in relation to the rehab agreement that Mr. Greenloff mentioned. That is separate from a settlement agreement, so if anyone has questions about that, let me know. I just wanted to clarify that he was not promoted to sergeant until 2019, so the 2016 DUI did not occur while he was a supervisor. And I wanted to answer the question about not resolved. Sir, you were correct. LAPD did not have body-worn cameras until 2015 is when they first came, and so a lot of the discourtesy allegations of that type were deemed not resolved because there was no way to show if a person did or did not say what was alleged. Those are adjudicated slightly differently now that we have cameras recording everything. I wanted to point out to you that you do have information in the documents that the division provided to you, specifically in the internal affairs investigation that LAPD provided to Post, showing what Sergeant Gaxiola has done since this incident. That particular investigation indicated that he had completed a 90-day rehabilitation program. It was specifically for first responders and dealing with post-traumatic stress disorder. He did the Alcoholics Anonymous meetings as a result of not only his criminal case in 2022, but for his own betterment as well. He continues that to this day. He participates in the alcohol abuse unit through the behavioral science services at LAPD, which is meetings with psychologists as often as they deem necessary, as well as a peer support member through that specific unit. So the information that you have in front of you from the division already shows the work that he has done since this incident occurred, which was in 2022, which is almost 3 years now that has occurred. I believe you also have the information of the rehabilitation agreement. It's not through the department, it's through the Board of Rights, which are 3 civilian members selected by the LA Police Commission to hear his case. And they are the ones that entered into that rehabilitation agreement with him and requires at least 2 times a month that he be tested for alcohol use, in addition to the rehabilitation programs that he's done separate from the 90-day one. The Alcoholics Anonymous meetings, his maintaining his relationship with his sponsor, meeting with him regularly. As you see in that agreement, he's required to report quarterly back to the Board of Rights with his progress. And the next board date for that is actually next week. And they will be making a determination at that point as to whether or not he has lived up to his end of the bargain. And then they will make a decision about discipline for this 2022 DUI, just so you're aware of that. So I wanted to bring that to the board's attention. I know you have those documents, but I wanted to bring those to your attention and see if there was any other questions that I could answer for you.
Thank you, counsel. Also, please thank him for the service he's providing now for the fire victims.
I will do that.
Thank you. Questions? Questions for counsel? Yes, please. Ms. Pena.
How long is this agreement in effect?
So this agreement is in effect for 1 year typically. However, there's a caveat in the agreement that if the board, sorry, not the board, on January 24th, when they have their meeting, they'll make a determination about discipline. They can either choose to terminate him or they can give him a number of suspension days up to 65 days. Whatever they decide, if they don't terminate him, if they give him some amount of suspension days, then LAPD itself has the option to extend that same rehabilitation agreement for another 2 years. So with the Board of Rights, it's a 1 year agreement and they've held that penalty in abeyance. They'll make the penalty decision and then the department can determine if they want to keep him on that same agreement for another 2 years. And he is required to agree to that if they choose it.
If that, you may not be able to answer this, but if that agreement goes away, if he serves his 1 year under that agreement, does he continue going to AA and have a sponsor and participate in the programs at work?
He will, because it has proved to be very beneficial to him in this time period. He has learned a lot since 2022. So he will continue going because he now understands that he is an alcoholic and will need to maintain that level of sobriety for the rest of his life. And the department has provided him a lot of support. In reality, they have done a very good job of supporting him through this and providing a lot of resources, both at the police station where he works in Newton Division, as well as just department-wide with their behavioral science services, which provides a lot of supports to officers with addiction.
And he's held accountable. I mean, people are making sure that he's attending 2 AA meetings a week.
Yes, for the Board of Rights, he has to provide proof of that, and they do a quarterly report. I made some notes about it. I know you don't have that yet, but in the first quarter, he attended 98 Alcohol Anonymous meetings. The second quarter, he attended 39. The third quarter, he attended 42. The next report will be given to the board next week, and I assume it will be similar numbers to that. I believe he goes at least 2 times a week, and he is tested twice a month for alcohol. I do this twice a month, but it's randomly. Sometimes it's 6 days apart, sometimes it's 4 weeks apart, but it's a random test where he's tested, and those have all, he has passed all of those.
Have they all been negative?
Yes.
For alcohol?
Yes,
Okay.
everyone. And he gave me a list of things that he's doing in relation to your question. He meets and speaks with one of the peer support members from the alcohol abuse unit on a regular basis. There are 2 people that he became friends with and supports with that first responder group that he meets with weekly to work out as well as discuss their stresses. He has another support group made up of 5 officers from the Task Force Heroes program that he participated in, that he has a group chat with where they text each other regularly for support. He has a live-in partner that he cohabitates with, and she is his main pillar of support. And then he relies on his family, his church, and he does a lot of physical activity to keep himself at a lower stress level so that he can maintain his sobriety. And he intends on doing that for the rest of his life.
So just as a kind of reminder to the board members, the things that are outside the 4 squares of the investigation report, such as things that prospectively might mitigate or trend towards a rehabilitation, are not really in front of us now and shouldn't be given weight. Rather, we're looking at what the investigation report and recommendation by division is. And then that's, and also consider this point. There could be things that could be brought in front of the ALJ that would militate towards a rehabilitation outlook, but those would need to be developed factually and can't be infused into the report by council statements. So that's just something to keep our eye on.
Thank you, counsel. Yes, Mr. Lloyd.
All right, so what is the sanction and how rapid is it if he fails any of these alcohol tests right now?
For the agreement that he has with the Board of Rights?
Yes.
It would be on the 24th of January. Then they would make a decision that they believed he violated that agreement. And my experience in that area is that they would terminate him on that day.
Thank you.
Questions for counsel by any other member of the board?
Johnson. Yes. I'm not clear on, maybe you can explain the Board of Rights. Who are they?
So LAPD's discipline system has a Board of Rights to adjudicate any discipline that is intended to be imposed by the chief of police. It's similar to a civil service hearing or an arbitration in other agencies. In LAPD's system, it's under their city charter. They can either choose to have civilians that are appointed by the police commission, or they can choose to have sworn law enforcement members of their own department decide their case. And it's like a little trial, but not like in front of a jury.
The other part of the question, I've heard an agreement with the Board of Rights, but did I also hear he had a second agreement?
I was just clarifying that that rehabilitation agreement that was mentioned by Mr. Gringolf was not like a settlement agreement in the previous case that you had heard about from LAPD. They're different types of agreements, but it's essentially like a probationary term to see if he can behave.
The Board of Rights agreement is just for 1 year.
Correct, with the caveat that if the Board of Rights determines that he in fact followed all of the parts of that agreement and they want to suspend him instead of fire him, then the department has the option to extend that agreement for up to 2 years at their discretion.
Questions or comments at this point?
May I just add one? I just meant to say that Sergeant Gaxiola is not disputing that this is a problem and that Post has the right to look at his actions on I think it was May of 2022. He's just requesting that this board recommend a suspension instead of a revocation. He's not asking that nothing happened. He understands that his actions have consequences. I just wanted to be clear about that.
Okay, thank you so much.
You all.
Is there anyone in the public that would like to address the board at this time? Anyone on the phone would like to do so? Okay, well, we are going to take a break. It is now 12:01. Although the board will be meeting in the room next door, we are not going to discuss this case at all because the court reporter will not be in the room with us. So what we will do is, do you think a half hour is enough time for lunch, everybody? Yeah? And does that give you enough time, court reporter? Okay, so let's plan on not talking about this case for the next half hour, eating our lunch, and then asking the reporter to join us at 12:31. Thank you. Let's see where we are. We're now reconvened to regular session to take a vote on the board's recommendation in the matter of case post 230-2971, Gabriel Gazzola, who at the time of the events at issue in the case was employed with the Los Angeles Police Department. Any comments on the matter? Is there a motion?
Yes, I'd like to make a motion, Madam Chair. I'll need some help from staff, and my motion would be along the lines of what the Post Commission has proposed with the DUI cases. And I don't know exactly every element of that, but that's what my motion, and that's what I support.
And is that for a 5-year or 10-year period?
A 5-year.
Okay, so that's the motion. Is there a second?
Second.
Okay, and
Clarification,
please.
because there are several versions of this. Is this decertify with a stay of the decertification?
Yeah,
What was your
yeah,
motion?
I'm sorry.
Go ahead.
To answer your question, Dr. Glazer, it would be deemed a revocation stayed for an order of stipulated settlement.
Okay, is that,
Yes,
is that your understanding?
that is my understanding.
Okay, and the second that you made, Mr. Laura, is that based on what was just stated?
Yes.
Okay, fine. So now we have a first, we have a second, we got clarification. Would you please call the roll vote?
Yes, thank you, Madam Chair. Clavo. Crawford. Doyle.
Yes.
Dudley.
No.
Glazer.
Aye.
Johnson.
Not in agreement.
Mr. Johnson, I think he needs a no or a yes from you, please.
I'm sorry, no.
Lara.
Aye.
Pena.
Aye.
Motion fails. That's 4 yeses, 3 nos, and 1 abstention.
Motion fails. Okay. So board discussion, or do people want just to take a second vote?
I have a question. How does the board, how does it fail?
Well, because we didn't get a majority,
Oh, okay,
we have to have 5.
okay.
So I guess we could, now that everybody knows that, we could just take another vote. See if that changes anything, or we can start looking at new motions. Let's try it again. Let's revote on the last motion that was made by Doyle and second by Lahr. And if you could take a vote, please, again.
Clavo.
Yeah.
Crawford. Doyle.
Yes.
Dudley.
No.
Glacier.
Yes.
Johnson.
No.
Lara.
Yes.
And Pena.
Yes.
Okay, so the votes came out the same, and therefore that motion doesn't pass. Is there any further discussion?
Can another motion be brought forward?
I'm sorry.
Can another motion be brought forward?
Yes, absolutely. That motion failed, and we have no motion before us now. Go ahead.
Then I would move that if we could consider the same revocation, stayed, and 10 years in the alternative in terms of the additional time for it.
Is that a motion?
That was a motion, sorry.
I'll second.
Okay, so now if you could take another vote.
Okay. Clavo. Clavo, aye. Crawford. Crawford, aye. Doyle.
Aye.
Doyle, aye. Dudley.
No.
Dudley, nay. Glacier. Glacier, aye. Johnson. Johnson, aye. Lara.
Aye.
Lara, aye. Pena.
Aye.
Pena, aye.
6-1. So there were no abstentions this time. Okay, that motion passes 6-1. Hang on, did I get that right?
7-1.
7-1, and that motion passes. No abstentions, 1 no. Okay, thank you, everyone. Okay, moving on to case 3. At this time, I would call upon law enforcement consultant Robert Bringelf, Professional Conduct Los Angeles County Bureau, and Brian Henley, attorney for Legal Affairs Bureau, to provide a report on case post 230-5109 Joshua Satterfield, who at the time of the events at issue in this case was employed with the Torrance Police Department. Please begin.
Thanks. Good afternoon, everybody. I am still Robert Bringoff, and next to me is Bryant Henley. I just want to put a little disclaimer out in front of this case. There's going to be some offensive language, some allegedly racist terms, some racist terms. So I just want to put that out there and just kind of forewarn everybody. As I said, I'm still Robert Bringoff. This is Bryant Henley. I'm assigned to PCLA. I'm here today to present case 235109 involving Joshua Satterfield. It is the division's determination that clear and convincing evidence exists to demonstrate that Joshua Satterfield committed an act of serious misconduct as set forth in Penal Code Section 13510.8 while sending text messages to coworkers between August 2018 and April 2019. Specifically, the division has determined that Joshua Satterfield committed the following acts of serious misconduct: demonstrating bias as defined in section 13510.8 sub B sub 5 of the Penal Code. This afternoon, I'm going to present a brief outline of our findings, and I will begin doing that now. So Mr. Satterfield began his law enforcement career with the Los Angeles County Sheriff's Office as a deputy trainee on January 9th of 2014. After that, he was promoted to deputy sheriff on June 1st of 2014. He had 10 days off between working as a deputy sheriff and starting as a police officer at the Torrance Police Department. And he holds a post-basic certificate, which was issued July 14th, 2015. On March 26, 2023, Torrance Police Department, or TPD as I may refer to them, reported allegations of serious misconduct against Mr. Satterfield to Post pursuant to California Penal Code Section 13510.9 sub A sub 3. The allegations stem from the discovery of homophobic, transphobic, and racist texts sent between members of the TPD between May 2018 and February 2022. When analyzing the serious misconduct allegation of Penal Code Section 13510.8 B5 and Regulation 1205 A5 demonstrating bias, the division evaluates whether the subject officer through words, action, or other conduct showed prejudice, intolerance, contempt, or hatred towards a protected class of persons. If the subject officer did show prejudice, intolerance, contempt, or hatred toward a protected class of persons, the division then considers whether the words, action, or conduct would lead a reasonable person to conclude that the officer has not or will not fairly and impartially perform the officer's law enforcement duties. If so, serious misconduct is shown if the officer's words, action, or conduct either 1, violate applicable law, 2, violate department policy, or 3, are inconsistent with the officer's obligation to carry out the officer's duties in a fair and unbiased manner. During the analysis of each instance of potentially biased behavior, the conduct was analyzed based on the guidelines I just mentioned to determine whether the allegation of bias was true to a clear and convincing standard. Regarding a message sent on August 23rd, 2018, Torrance Police Officer Chavez sent a text to Officer Satterfield that was a link to an article titled, quote, "Grand Rapids man accused of urinating on Black child, calling her N-word," end quote. Chavez wrote, "Josh when he's older." Satterfield wrote, "What's the crime?" End quote. The exchange between Officer Chavez and Officer Satterfield is inherently offensive and racist. Satterfield's conduct in sending the message, "What's the crime?" in response to an article describing allegations of an adult male urinating on a female child and calling her the N-word, clearly shows prejudice. Even when viewed in the light most favorable to Officer Satterfield, the "what's the crime" response shows his indifference toward a specific protected class. This necessarily erodes the public's confidence in his ability to fairly perform his law enforcement duties. This message constitutes a demonstration of bias. It's also highly probable that a reasonable person would conclude that Mr. Satterfield's August 23rd message, in which he asked, "What's the crime?" in response to an article entitled "Grand Rapids man accused of urinating on a Black child, calling her the N-word," demonstrates that Mr. Satterfield has not or will not fairly and impartially perform his law enforcement duties when interacting with a protected class of persons. The message exchange and respondents, sorry about that. Just lost my spot here. My computer was helping me in going back to the top of the page, so give me a second. Okay. The message exchange and respondents' "What's the crime" response violated several of the Torrance Police Department's policies, including but not limited to TPD's anti-harassment policy, which is 34.05 at SEEK, and General Orders 1.10, 1.10.3B, and 2.33.1D. Accordingly, the division finds that Satterfield demonstrated bias with the meaning of Penal Code Section 13510.8B5 and Regulation 1205A5 when he responded, "What's the crime?" to Chavez's message. On December 13th, 2018, Officer Chavez sent a group text thread, a photo from the social media account of a T-Flats wrapper that contained an image of an assault rifle sitting upright on a table with a target underneath. After some discussion, Satterfield messaged the group, "You happen to notice the rounds put through that target on the table? I'm confident he won't be hitting any of us with that unzeroed EO tech." EOTECH. Kind of reminds me of Chandler's targets by evidence of, and then he named a member of the Torrance community that I refer to as IP1 in the division's investigative summary and findings. Officer Chandler responded, "I'm a dead-eye shot, biatch. Who's IP1? Officer Satterfield replied, "That niglet you failed to kill. Grandma said you need to be a better shot," end quote. Mr. Satterfield's message clearly shows prejudice and intolerance. Satterfield refers to a member of the Torrance community as that niglet and goes on to criticize Officer Chandler because he, quote, failed to kill the individual during a previous police encounter. Even when viewed in the light most favorable to Mr. Satterfield, his racist epithet used to describe a member of the Torrance community and statement that Officer Chandler failed to kill the Torrance community member shows his indifference toward a specific protected class. Again, this necessarily erodes the public's confidence in his ability to fairly perform his law enforcement duties, and a reasonable person would conclude that Mr. Satterfield's message shows he has not or will not fairly and impartially perform his law enforcement duties when interacting with certain protected classes of persons in the Torrance community. Further, the specificity of the language in this exchange is severe, as Satterfield asserts that Officer Chavez failed to kill a member of the Torrance community, an individual Satterfield identified using an offensive term associated with that community member's apparent race. Coupling the racist epithets with the implication that the appropriate outcome to a use of lethal force is the death of the suspect rather than stopping the threat also suggests a reasonable person could conclude Satterfield's statement reveals Satterfield's predisposition to use force in an unfair or biased manner. Stated another way, a reasonable person would also conclude that Satterfield believes the appropriate use of force will depend on the suspect's race. This type of statement violates several department policies and discredits the Torrance Police Department in potentially irreparable ways. His remarks violated several of the TPD policies, including but not limited to TPD's anti-harassment policy and general orders. Accordingly, the division finds that Mr. Satterfield demonstrated bias with the meaning of Penal Code Section 13510.8B5 and Regulation 1205A5 when he wrote, "That niglet you failed to kill, Grandma said you need to be a better shot." On April 30th, 2019, Torrance Police Officer Nelson shared a Black Lives Matter Instagram post to, quote, the boys group chat. The post read, quote, "Torrance, California police shot and killed," and then we've omitted the decedent's name, "within 15 seconds. Just released body cam footage shows police murder, decedent's name is omitted," and then there's an ellipses, end quote. Mr. Satterfield replied, "Ah, and his little son will grow up without a father now. Oh, wait, that's standard for any African-American family to be absent a father. He'll be fine," end quote. Mr. Satterfield's April 30th message shows prejudice, intolerance, contempt, and hatred towards a protected class of persons. Mr. Satterfield facetiously laments the death of a member of the Torrance community by messaging "aw." He then goes on to reinforce racist stereotypes and expresses a callous indifference concerning the future of the decedent's child when he states, quote, "The decedent's little son will grow up without a father now. Oh, wait, that's standard for any African-American family to be absent a father. He'll be fine," end quote. Death of a member of the Torrance community by using racist stereotypes, while at the same time displaying no empathy for the decedent's young son. A reasonable person would conclude that Satterfield's message demonstrates he has not or will not fairly and impartially perform his law enforcement duties when interacting with certain protected classes of persons in the Torrance community. Further, the April 30th message is another message that discredits the Torrance Police Department in potentially irreparable ways. His remarks violated a number of their policies, to include but not limited to TPD's anti-harassment policy, as I've mentioned before, the general orders 1.10, 1.10.3b, and 2.33.1d. And accordingly, the division finds that Mr. Satterfield demonstrated bias within the meaning of Penal Code Section 13510.8b5 and Regulation 1205A5 when he wrote, awe, and when he wrote, quote, "His little son will grow up without a father now." The facts I've just recited support the division's finding that Joshua Satterfield was involved in serious misconduct, specifically demonstrating bias. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Joshua Satterfield's post certification be revoked. With that, I'm happy to answer any questions that the board may have.
Does anybody have any questions? Is there anyone in the public that would like to address the board at this time? Yes. And let me just say that, pardon? Okay. We haven't gotten to that. You may state your name and organization if you wish. You'll be given 3 minutes to speak, and the time limits will be strictly enforced, so please ensure that you complete your comments within that allotted time.
My name is Beatrice Johnson, and I am here with Families United for Justice, which is a network of families who have lost loved ones to police killing. Some have actually had racial epithets before they were killed, including Oscar Grant. I want to talk about the mindset. It's devastating that in 2025, 2024, that this kind of mindset still exists, and it still exists in the police department. As you know, for the community like mine, we understand that policing started with slavery, catching slaves. That mentality still exists today. It's very heartbreaking. It's painful. It was very painful to hear this case, him reading this case. I really wasn't prepared for it today because we do have a network of over 1,500 families who have lost loved ones to police, and a lot have experienced this racial epithets before their loved ones was killed. So I feel like if we're going to change the culture of policing, that mindsets like this should not be tolerated in any way, That's all I want to say.
Thank you, Mrs. Johnson. At this time, does the subject officer and/or their counsel wish to make a public statement? If so, you'll each be given 4 minutes to speak, and the time limit will be strictly enforced. So please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented in the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following: if the facts offered by the division today are in fact proven at a later hearing, do these facts demonstrate a high probability that serious misconduct, as defined in Penal Code Section 13501.8 and Commission Regulation 1205 occurred? So do we have the attorney or the respondent?
Yes, can you hear me?
Yes, we can. Thank you.
Yes, hi, good afternoon. My name is Tom Yu. I am Officer Satterfield's legal counsel. I just want to make sure my sound bite's coming in because it's not, I don't see myself on the Zoom meeting.
I'm hearing you and the board
Okay,
is.
because,
perfectly
okay,
well. Thank you.
very
for
well. I wanted to comment on 3 things, and I'll go in turn. If the facts proven in this allegation is true, there is not a amount of evidence that would tend to prove that any of these text messages, number one, was sent by my client, Officer Satterfield. Nothing the record would show that Officer Satterfield himself sent this message. The standard is words of tolerance or contempt for hatred of protected class, and whether or not those actions would implicate any type of effect that my client cannot perform his official duties in a manner consistent with department policy. There has been zero evidence of all the investigations that Officer Satterfield had any racial bias towards any minority groups. The T-flat case that the law enforcement consultant was talking about was a Hispanic gang member that was killed after a confrontation with Officer Chavez Concannon. That was a separate incident that my client was not involved in. The facts in this case tends to conflate that Officer Satterfield had some involvement in that shooting. In fact, my client had zero involvement in that shooting, and nothing here demonstrated or would tend to prove that Officer Satterfield took any enforcement actions that were biased or had any kind of ill will towards any race of any minority races. The anti-harassment policy that the commission has referred to does not apply here. If proven at a hearing, the anti-harassment policy for the Torrance Police Department is not to use any race, gender, or otherwise protected class to engage in inappropriate behavior of city employees. So when the consultant is talking about this anti-harassment policy, that is very misleading. The anti-harassment policy is not to prevent I'm not saying the officer should harass the citizens, but the policy that he cited does not apply in this case, nor is there any kind of evidence that tends to point out this disposition that my client has any kind of ill will towards minority groups. That type of reasonable person predisposition is founded for nothing but speculation. It is speculation that my client did something to a citizen of the Torrance community because of their race. In fact, if you look at Officer Satterfield's arrest, most of the people he arrested were Caucasian. They were not Blacks or Hispanics. I think to end the public comment, what is shameful for the Torrance Police Department is how they got these messages. They illegally searched another officer's phone and extracted private text messages that they would not otherwise in possession of. I think it should not be lost in this commission that law enforcement officers in all fronts should uphold the law, and they cannot break the law to enforce the law. Thank you for your time.
Thank you. And just a comment back, there has been no designation, no lawful designation that the taking of that messages was illegal. Okay, any other questions or comments from the board for Mr. Yu?
Mr. Yu, so it's your position that there's no proof that your client sent those text messages?
Correct.
Thank you.
Well, it's my position for the purposes of this public comment with the evidence presented. Yes, Mr. Doyle.
Thank you.
Okay, Ms. Pena?
So just to follow up on that, because I'm a little bit confused. So your first argument is Satterfield didn't send these messages and there's no evidence to prove that. But your second argument is even if he did, it doesn't show he doesn't have racial bias?
No, the second argument I have is from the messages presented by the consultant in this hearing, those messages themselves do not demonstrate the second prong of whether these words or actions or conduct has an impact of my client's official performance of his duties as a law enforcement officer. His comment and plain jokes of African Americans or Hispanics or whatever race, there's no evidence that's linked to any of his performance as a law enforcement officer, or whether or not those text messages or statements purportedly made by him had any impact on him while performing his duties as a police officer.
I'm not sure that Ms. Pena is done. Hang on. Ms. Pena, did you have anything else?
That's fine.
Okay, thank you.
Board
Ms.
Member
Crawford?
Flavo.
Oh.
As a Black female, as a Black woman, as a mother of a Black child, I'm having difficulty understanding or hearing that you think or you believe that racial epithets in a text message has no weight or bearing on how a person goes about their daily responsibilities and completing their job. I, as a citizen, taxpaying citizen, could not put my trust in any organization, be it police, fire, any type of public service, medical, into a person who thinks it's okay to have those type of conversations.
I don't think that was a question for you, Mr. Yu. I think that was a statement as to her feelings.
Yes.
Thank you.
Thank
So
you.
moving on to Ms. Crawford.
Thank you. She pretty much said the same thing I'm thinking as a mother, as a community leader, as a community citizen. One of the things that I find insulting is that he himself did not appear before this board. What we read and what we see in evidence is serious. I am a mother of 2 sons and a daughter, and I have a grandson now, and I pray every day that my children do not come before an officer with that type of mindset or spirit or in their heart. It would have been better for him to come before this board because, as we know, you're a paid attorney, and the best attorneys who may project a story is not always evidence to truly how he felt. He did himself a disservice because if he truly believed this or it wasn't him, he should have been before this board. And that was my comment.
Okay, let me just make sure everybody understands. He had no duty to appear before this board. We don't know why he's not appearing before this board. It just is that he's not appearing before this board. Any other questions or comments? Dr. Glazer, then Mr. Lahr.
Just for clarification, given that Mr. Yu implied or insinuated that there would need to be evidence linking the expression of these racial bias with actual performance or actual behavior, the penal code, the relevant penal code language says an officer is demonstrating bias for purposes of this regulation when the officer either shows or displays by words, actions, or other conduct prejudice, intolerance, contempt, or hatred towards one or more persons due to that person's membership within a class of persons identified in Penal Code Section 13510.8b5, when such words, actions, or other conduct would lead a reasonable person to conclude that the officer has not fairly and impartially performed or will not fairly and impartially perform their law enforcement duties. And that is our guiding language. And then I would like to say, as a researcher of prejudice and discrimination who's been studying that for over 30 years, that attitudes do affect behavior. And it's a reasonable inference that if somebody expresses these kinds of hateful, racist attitudes in one context, it could very well influence their behavior in another.
Thank you, Dr. Glazer. Yes, Mr. Lahr.
Question again for the investigator. I want Robert, it is being said by the attorney that it was not established that Mr. Satterfield sent these messages. Could you just lay out to us how you established that he sent these messages?
Yeah, I would direct your attention to attachment E, which are transcripts from his interview with Internal Affairs. We were able to correlate the phone number that was on the WhatsApp messages to his personal cell phone number. And then in his interview, I could read it to you, or you can just take a look at attachment E, but it essentially, they ask him about, have you had this cell phone? How long have you had this cell phone prior to working at Torrance? Did anybody else use your cell phone? So his attorney at Mr. Yu, I believe at the time, said, well, that assumes that person told him that they used his cell phone. But then it was cleared up so that no one has told you, or that no, he hadn't discovered that anybody else used his cell phone to send these messages. There's no indication to believe that somebody else sent those messages. So I believe the clear and convincing evidence standard has been met. Yeah, I would bring your attention to attachment E. There's not a doubt from this investigator standpoint, that those messages were sent by his phone and likely sent by him.
I asked the question, I saw the attachment. I asked the question in the vein of just making it clear for the listeners who may not be privy to that material.
Yeah, thank you.
Thank you, Mr. Laurie.
Madam Chair, may I respond to the comments that were made?
Not yet. Let me make sure there aren't any more comments. Looks like Mr. Johnson has a comment.
I do, and I believe this is also for the division. The particular group that his number and his association with, what do we know what this particular group was formed for, and were there other racial epithets used in this same group?
Yeah, there were. I don't know why it was formed necessarily. I think it was just a communication platform. So it was like a group of people from an agency that would all text and communicate on the same platform. I think they used WhatsApp in one of these instances. Other instances were just texts, like iChat texts. Yes, there were other racial epithets used. You'll hear another case today. The case following mine is another case that the case was born out of the same incident, right? So same agency and a different officer, and different text messages that are all related to one another. That's the next case that you'll be hearing. So yes, there are others. Does that answer your question, Mr. Johnson?
It does to a degree. What about the size of the group? How big was the group?
Oh gosh, I don't remember specifically, but so the one thing, the one thing to remember is not all of these messages happened in the same group. So some of these text messages were sent in smaller groups of text sent between different people. They all have a common person though, or common people, and those people were two officers who were subject to a search warrant. And so those people had to be involved in the text chains. We don't know what text happened outside of those. And so these are different groups that all involved two specific officers. Please, yeah.
Anything else, Mr. Johnson? Please, go ahead.
Madam Chair, if I
Yeah,
may, just
sure.
to add to Mr. Bringolf's answer, Board Member Johnson, these threads of text that you've heard today came from a group chat. So WhatsApp being one of the applications that you can communicate via text. These were handled on WhatsApp. There was a group of 15 police officers, either former or current police officers working for the Torrance Police Department, that were part of this group. The group was labeled the boys, quote unquote, and the messages were communicated to, quote unquote, the boys. Respondent, Officer Satterfield, former Officer Satterfield, was among the 15 persons who were part of that messaging thread.
Any other comments before I turn it back over to Mr. Yu for a minute? Okay, seeing none, Mr. Yu, I'll give you 1 minute to respond.
Thank you very much, Madam Chair. The standard of what would lead a reasonable person to conclude is purely speculative. The evidence before this commission has zero evidence that would lead a reasonable person to believe that Officer Satterfield used some kind of racial bias when he was performing his job as a police officer. You would think the Torrance Police Department would go back to years and years of arrests, citizens' complaints, nothing to that sort. You are looking forward where you should be looking backwards. Looking forward is speculation. When you're looking forward, you're saying what might happen, what could happen, as Dr. Glazer could say. What could have this officer done? But what did happen was nothing happened. Nothing of racial discrimination, nothing of racial harassment occurred. Torrance Police Department did an in-depth investigation on the entirety of all of Officer Satterfield's arrests, and they came up with nothing. Zero evidence to show that race was even a factor in his previous arrest. Thank you very much.
Thank you, Mr. Yu. You did get your minute. And everybody heard the piece that Dr. Glazer read, and you also heard from Mr. Yu. Mr. Yu, thank you. Would you like to deliberate or not?
Madam Chair, if
Yes.
appropriate, I would like to respond to Mr. Yu's comments. I defer to you.
Absolutely.
Oh, thank you. There are really 2 points, and Dr. Glazer of your board has already addressed one, and I don't want to belabor it, but I respectfully want to submit that Mr. Yu has mischaracterized what the statute and the regulations say. And just to try to bring us back to what the regulation says, it's important to emphasize it's not a question of whether Mr. Yu or his client believe that they are engaging in racist behaviors. The question is whether through the words, acts, or other conduct, would a reasonable person conclude that the officer has not fairly and impartially performed or will not fairly and impartially perform their law enforcement duties. We would respectfully submit to you that the evidence is much higher than clear and convincing. There's a monument of evidence to demonstrate that a reasonable person reading these text messages among 15 officers would easily conclude this officer cannot fairly and impartially perform his duties. The last point I would just like to make briefly is Mr. Yu references that there is no evidence that these texts resulted in any racial or discriminatory behavior. And I think it's worth mentioning at this point, it's in the investigative summary and findings. The reason these text messages came to light started with 2 other peace officers, Officers Weldon and Tomsick, former officers. They're currently under a criminal prosecution for their conduct. What led to these texts being found was that a swastika was spray painted on a victim's car. It turns out that right now, those individuals, Officers Tomsick and Weldon, are being prosecuted for the spray painting and vandalism in a felony case, spray painting that swastika on a vehicle. Precisely the types of behaviors that are abhorrent and can be found within the text messages that were found following that investigation. And so I respectfully but strongly disagree with Mr. Yu's characterization as to whether these messages have any importance or not.
Okay, so here's my question. Would anybody like to go in the back room and deliberate on this case?
No.
Okay, there is a no response from everybody. So now let me ask if there's a motion.
I'd like to make a motion to revoke.
Okay,
I second it.
okay. Discussion, comments, questions? All right, please take a roll call.
Thank you, Chair. Thank you, Madam Chair. Clavo,
Yes.
Clavo, I, Crawford,
Yes.
Crawford, I, Doyle,
Yes.
Doyle, I, Dudley, Dudley, I, Glazer,
Aye.
Glazer, I, Johnson,
Aye.
Johnson, I, Laura,
Aye.
Laura, I, Pena,
Aye.
Pena, I. Motion passes unanimously.
Thank you. Are you ready for a break? I'm sorry. Yes. Yes, okay. Let's take a break now. It's 1:45, and if I could please ask everyone to be back by 1:55. We still have 3 more cases, and it's close to 2 o'clock. Thank you.
Yeah,
ready?
exactly.
Okay, it's now 1:55. Thank you all for being on time. And let's move on to the next case. That's Blake Williams. At this time, I will now call upon law enforcement consultant Laura Lynn Kong, Professional Conduct, Los Angeles County Bureau, and Brian Henley, Attorney for Legal Affairs Bureau, to provide a report on case post 2305781 Blake Williams, who at the time of the events at issue in this case was employed by the Torrance Police Department. Thank you.
Good afternoon, Chair Dudley and members of the board. My name is Laura Lynn Kong. I'm one of the law enforcement consultants assigned to the Professional Conduct Los Angeles County Bureau in the Peace Officer Standard and Accountability Division. With me today, again, it's Brian Henley, an attorney with our Legal Affairs Bureau. I'm here today to present case number post 2305781 involving Blake Williams and the Torrance Police Department. It is the division's determination that clear and convincing evidence exists to demonstrate that Blake Williams committed acts of serious misconduct as set forth in Penal Code Section 13510.8 between July 2018, and September 2019. Specifically, the division has determined that Blake Williams committed the following acts of serious misconduct. Penal Code Section 13510.8B5 and Commission Regulation 1205A5 demonstrating bias on the basis of race, religion, and sexual orientation. The serious misconduct in this case not only violated the Torrance Police Department's policies, the misconduct was completely inconsistent with the peace officer's obligation to carry out the officer's duties in a fair and unbiased manner. In this presentation, I will present a brief outline of the division's findings of investigation in this matter. Blake Williams began his career with the Torrance Police Department on June 9, 2016 as an officer. Blake Williams holds post-certification, their basic certificate, which was issued on June 12, 2017. He has 2 previous incidents of discipline. One was for an incident that occurred on July 5th, 2018, related to a policy violations associated with a vehicle pursuit. Respondent was issued a 1-day suspension. The other was for an incident that occurred on May 11, 2020, related to policy violations associated with discourteous, disrespectful, or discriminatory treatment of any member of the public or any member of the Torrance Police Department or the City of Torrance. On May 20th, 2020, respondent was issued a written reprimand. The discourteous treatment at issue did not involve bias. Just to give you a little background on this investigation, I know some of it is a little repetitive from the last one. In January 2020, 2 Torrance police officers were the subjects of a criminal investigation wherein it was alleged they had vandalized an arrestee's vehicle by, among other things, spray painting a swastika on the interior of the arrestee's vehicle. As a result of the criminal investigation, Torrance police detectives obtained a search warrant for the officers' personally owned cellular telephones. The data extracted from the cellular telephones was forensically analyzed by an investigator with the intent to determine whether the 2 suspect officers had any ties to white supremacy. During the review of that data, it was discovered that approximately 390 messages were sent between the 2 officers as well as other officers, including respondent. Several of the messages were believed to contain or reference racist, discriminatory, and/or anti-Semitic remarks. The forensic review revealed respondent was part of a WhatsApp group text titled The Boys, which included approximately 15 members of the Torrance Police Department. WhatsApp is a cellular telephone app used for sending text messages. Based on this information, the Torrance Police Department utilized Norman A. Traub and Associates to conduct the administrative investigation. This investigation was separate from the other 2 officers' criminal investigation. The administrative investigation as it relates to respondent focused on 13 messages that were received, sent, or responded to by respondent while on and off duty that were alleged to demonstrate bias. Of the 13 messages, all but 1 were sustained as being policy violations related to receiving, sending, and responding to discriminatory text messages. 6 of these messages are described in further detail within the investigative summary and findings and are the subject of today's meeting. I will review the actual text messages and photos with you and then address each one. Please be advised, the content about to be shown contains offensive material due to the topic of the allegations. Next slide. On July 4th, 2018, in a WhatsApp message to the boys group, respondent mentions Officer David Chandler needing to get off probation Officer Chandler responds, "I'll eat sweaty ass at this point with dingleberries." End quote. Slide 4. A few minutes later, respondent replied with an image of a male adult in blackface. Respondent's post, "I Googled dingleberry and this popped up. Way funnier." According to the Merriam-Webster dictionary, blackface is a dark makeup worn to mimic the appearance of a black person, and especially to mock or ridicule Black people. Note, the wearing of blackface by white performers was from early 19th through mid-20th centuries, a prominent feature of minstrel shows and similar forms of entertainment featuring exaggerated and inaccurate caricatures of Black people. The use of blackface is considered deeply offensive. The division believes the respondent's statement that the blackface photo is way funnier than other Google search results he obtained for the term dingleberry shows his disregard for a specific protected class of persons and is inconsistent with the respondent's obligation to carry out his duties in a fair and unbiased manner. It is highly probable if a reasonable person saw or heard about this message, they would conclude that the officer will not fairly and impartially perform their law enforcement duties. The Torrance Police Department found the message violated several of the department's policies, including but not limited to the prohibited use of obscene, indecent, profane, or derogatory language while on duty or in uniform, and the prohibition against bias-based policing. It is the Torrance Police Department policy to provide law enforcement services and to enforce the law equally, fairly, and objectively, and without discrimination toward any individual group. The Torrance Police Department reviewed several text messages, including the same text messages which are part of this division's investigative summary and findings. The department concluded that the respondent's involvement in sending, receiving, and responding to discriminatory messaging constituted grounds for respondent's termination. Next slide. On July 5th, 2018, respondents sent a WhatsApp group message to the boys. The message contained an image of two muscular Black males fighting or wrestling. Respondent's caption message was as follows: "Hey, young, every day you don't work out, just know some gorilla-looking fuck is getting it in over in the Shadowlands." Young is believed to be Torrance Police Department Officer Young, a member of the boys group chat. The division believes the reference gorilla-looking fuck is referring to the two muscular Black males in this photo. This message is racist and offensive, and an offensive characterization of the individuals in this photograph. It is also inconsistent with the respondent's obligation to carry out his duties in a fair and unbiased manner. It is highly probable if a reasonable person saw or heard about this message, they would conclude that the officer will not fairly and impartially perform the officer's law enforcement duties. The Torrance Police Department found this message violated several of the department's policies, including but not limited to the prohibited use of obscene, indecent, profane, or derogatory language while on duty or in uniform, and the prohibition against bias-based policing. It is the Torrance Police Department's policy to provide law enforcement services to enforce the law equally, fairly, and objectively, and without discrimination toward any individual group. The department concluded that this message, along with other discriminatory messages that respondent either sent, received, or responded to, constituted grounds for respondent's termination. On August 23rd, 2018. One of the messages to the boys mentioned Omar, who was believed to be Torrance Police Department Omar Alonzo, who was one of the members of the text group. The message string began with respondent. Omar was, though, jam him up. Officer Joshua Satterfield responds, I'll Superman punch Omar on the run and then just keep going and see if they chase me. Respondent replied, bro, not a good idea. The big brown war machine would not be pleased. Generations of field work has left his knees numb and calloused. Officer Satterfield responds, I can outrun Omar. I'd have to be careful hopping fences, though. That's where he'd gain his ground. Respondent replied, Omar's people excel at fence hopping, at fence hopping too. Officer Satterfield replied, oh shit, LOL, sick burn. The division's analysis is the division believes this message is a stereotypical and derogatory reference toward Latin Americans. The use of stereotypical and demeaning descriptions of Latin American persons as means of amusement or in a joking manner are inconsistent with an officer's obligation to carry out his duties when interacting with this protected class of persons in the Torrance community. It is highly probable if a reasonable person saw or heard about this message, they would be offended by the stereotyping of Latin American field workers and or the reference to Latin American fence hopping. The Torrance Police Department found this message violated several of the department's policies, including but not limited to prohibited acts on or off duty that brings discredit to the department and prohibition against bias-based policing. It is the Torrance Police Department's policy to provide law enforcement services and to enforce the law, equally, fairly, and objectively, and without discrimination toward any individual group. The department included that this message, along with other discriminatory messages that respondent either sent, received, or responded to, constituted grounds for respondent's termination. Next slide. On November 4th, 2018, members of the boys chat group were discussing the types of inappropriate content that might be found on other Torrance police officers' social media accounts. The text message from Officer David Chandler to the boys' WhatsApp group reads, dude, you have no idea. I'm literally on fire right now. I can't believe we hired a racist cock like this. Don't we check Facebooks and shit? WTF is this? Next slide. Shortly after, the respondent sent a message that contained the image of a scene of a lynching, including 2 apparently deceased Black males who had been hung and a 3rd apparently deceased Black male down on the ground. There was a group of older white males looking on. Respondent commented, they missed this on mine. Officer Chandler responded, Jesus, Blake, ha ha. That's history though. There's knowledge in that. Shortly after that message, respondent sent another message, hanging with the homies. According to the NAACP, a lynching.
Ms. Kong, let me just stop you for 1 second.
Yes.
I want to ask the board members, is there anybody who hasn't read all this and considered all this? Do you need this reiterated in any way, shape, or form, the evidence that was in your binder? Yes, Dr. Glazer?
I will say that some of the context is somewhat helpful. I didn't understand the reference previously to they missed this one on mine, for example. That just was the beginning of the quote. So if there's any other context like that that explains and clarifies some of this, that would be welcome. Otherwise, I think we get the point.
Okay, anybody else have any? We'll keep going then, because I want you to feel that you have gotten all the information. Okay, thank you, Ms. Kong. Please go ahead.
Okay, I'll just go through the slides. Okay, just according to the NAACP, a lynching is a public killing of an individual who has not received any due process. They were violent public acts with white people used to terrorize and control Black people in the 19th and 20th centuries, particularly in the South.
Again, the message from the board was if there's any context, additional context. So Dr. Glazer, just to be clear, you don't need anything reiterated that was in your binder. It's just that there's anything additional. So given the nature of this information, given that the board has seen it, let me just ask you to shorten your comments and just include anything along the lines that Dr. Glazer was requesting.
Thank you, Madam Chair. I think with that, we'll, because I think this board understands the regulation and how it applies and with regard to these messages, I don't think we'll have to describe how we concluded that, but of course, we're prepared to answer any questions you may have. And Laura, with that, I think just kind of moving through the rest of the slides without reading.
Oh,
this.
keep going. Okay.
I would just go to the next
Okay,
slides for
next slide.
context. And maybe we can just allow the board to read it. This provides the context for the messaging. We'll give the board some time to read this message and we'll move on to the next one if that's appropriate. If the board, we have one more slide to show, and if the board's finished reading this slide, okay. And this is the final message that's within the investigative summary and findings, of course. If there are questions, the slide speaks for itself, but if there are questions, we are prepared to answer any questions.
Okay, again, I think you've all seen this. So are there any questions about context or anything else? Yes.
On an earlier slide, there's a reference in one of the messages to Shadowlands. Does that have any significance or does that mean something?
Thank you, Board Member Pena. It's certainly speculation, but the reference to Shadowlands, meaning sort of a darker area, it is really derogatory towards persons of a certain race. That's I think how some reasonable persons could construe it. I defer to every board member to interpret it as they will, but I think is certainly an implication there. Shadowlands was meant as a reference to persons of a certain color who are not in the open, but in the shadows.
It's not a specific location.
Certainly, I don't think either of us construed it to be a specific location, no.
Okay, thank you.
Any other questions for either the consultant, Ms. Kung, or the attorney, Mr. Henley? Okay, thank you both. At this time, does subject officer and/or their counsel wish to make public comment? If so, you will each be given 4 minutes to speak and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? Now, is anyone who would like to make a comment? Either or counsel?
We may have counsel online. I'm looking to our colleagues here.
Okay.
Good afternoon. Corey Glaive is online. My mic is open, but my video is not.
Now, Mr. Glaze, Joyce Dudley here. We can hear you.
All right. Thank you, Chair Dudley. It's nice to see you again. Honorable board members, thank you for the opportunity to address you. This matter comes before you without a final decision from the employer, as the appeal process for the discipline is still pending. We would ask that you do not attribute other officers' conduct to my client, as it's not relevant and he did not participate in those other activities for which you were discussed. The search warrant that brought the messages here had a specific order from the court that has been reaffirmed by the court of they could not use, review, or disclose, yet here we are using the same messages. Even if the facts are true, there is no actual conduct for post to act on. No evidence officer acted inconsistent with peace officer obligations to carry out his duties in a fair and unbiased manner. No allegations of bias other than certain memes. No allegations of excessive force or any other allegation that falls under Penal Code Section 13510.8B. There's no comments here directed towards any community members or anybody of the community. The investigator has analytical gaps that the use of means created by others and accessible on the internet would leave a reasonable person to conclude respondent has not acted or will not act fairly in his law enforcement duties. In fact, there is no evidence of any bias. The department looked into it on his arrest and his actions and determined there was no other bias. I understand you are now using a regulation that has recently been enacted and it appears using a law that doesn't go into effect until January 2026. Importantly, supposition and belief or speculation does not constitute facts, let alone clear and convincing evidence. And throughout this, you've heard suppositions. There is no evidence. And it's important to note that these are messages from 2018-1 and 2019 before the laws that you are now acting under. And there's no exception of 1315, 13510.8G as far as the subsections. You have heard reference to other cases that aren't before you in the arguments. In one case, there was a shooting. My client showed no bias. And in fact, he was the officer that moved forward in front of other officers, pulled the suspect out of the car and tried to save his life. On multiple occasions, he's tried to save people's lives. He was a combat medic. He treats people without regard to bias, both American soldiers and enemy combatants. As post trains, all persons have bias. Myself, my client, everybody on this board, some of them have been expressed today. The problem is only where you show that you act on that bias and it interferes with one's profession. There is no evidence of that in this case.
Mr. Glaves, you have another 25 seconds.
I have much more than that, but I know how the board's going to vote and probably won't even deliberate. So I will allow them to take the actions that they need so that we can get to an appeal hearing.
Okay, that's your choice. Thank you. Any comment from the attorneys at this point?
Oh, Madam Chair, if I may, I would address a couple of, there are obviously a litany of arguments that were presented here, maybe only a couple that are worth emphasizing. There's a suggestion that there hasn't been a final decision from the employer. That's incorrect, as the investigative summary and findings shows. That finding, the way that the City of Torrance policies work, they have an ordinance that they impose. It's Torrance Municipal Code Section 14.47.1. It provides the city manager with the authority to make a final decision on termination. The city manager indeed has made that determination. It's among the attachments you have to this investigative summary and findings. What Mr. Glave, I believe, is referring to is the fact that his client has appealed that decision. But again, that is of no matter, as the penal code provides in Penal Code 13510.8 subdivision C6, that an action by an agency or a decision that results from an appeal of an agency's decision does not preclude action by the commission. So suffice it to say, even were this, it is under appeal, that has no import on whether this board and the commission can take action irrespective of some appeal that may be existing, keeping in mind that this is conduct that first was discovered in 2020. We're now in 2025, and begs the question how long we should wait to take action in this case. The only other matter I would address is there's a discussion about a search warrant, the fact that the search warrant, that there were orders from the court regarding how that search warrant could be used. As Chair Dudley has already referenced, and it's in your investigative summary and findings, Mr. Glaive and his colleague, Mr. Yu, on behalf of their clients, went to the court, attempted to make the very arguments they're making for you today. The trial judge rejected those arguments. Mr. Yu and Mr. Glaive appealed that decision. The Court of Appeals summarily denied those arguments. And if Mr. Glaive and Mr. Yu wish to make those arguments again, if this board recommends revocation and the commission concurs, there will certainly be another opportunity for them to brief it in more fulsome detail if they wish to do so. The other last piece I'll say, and again, I don't want to belabor it, but it's really important to emphasize, since these are the first two bias cases that have been presented to this board, there's been a lot of argument and suggestion that somehow if you can prove that you've acted on your bias, that's what's required for this regulation. That seems to be the argument we're hearing. That's absolutely incorrect. That's a mischaracterization of what the regulation says. And I see heads nodding, so I won't belabor it, but I will finally say for the record, the question here for this board is, would a reasonable person believe, after seeing the messages, the communications, would they believe that that officer who communicates in these ways could fairly and impartially perform their duties? We respectfully submit absolutely not, and that's why we brought this case to you today. And with that, Madam Chair, I have no further comment.
Thank you. Yes, please, Ms. Crawford.
That's real quickly with Christopher, if that's okay.
You want to ask a question of the attorney?
Offline for a second, real quick.
Well, there's nothing offline, but you can certainly ask a question.
So that it is publicly known, I am a representative of the NAACP.
Madam Chair, if we could ask her to bring her mic down, I can't hear her.
Yeah.
Oh, you know I hate this thing. It is known that I am a representative of the NAACP, serving in several different capacities. I do not want to taint the counselor's position or post, so I don't know if I should recuse myself from this or not. And so, Christopher, I'm looking for your advice.
Yeah, I mean, I think in an abundance of caution that when somebody feels like a presence of potential bias could impact the progress of a case without specific to this one individually, I think it may be that a recusal makes sense. And so in that context, without like analysis of there's an actual issue of bias in your, because I have not heard enough from you to make a determination as law, right? Like this is what I advise as legal counsel, but based on the potential, sometimes recusal is a wise decision. So that's my knee-jerk reaction, and you know, potentially some of your other colleagues. Well, that's what I would say.
I think you described it beautifully, and I think you could make that internal decision. Thank you. Other questions or comments?
I have
Yes.
just want a clarification with post counsel. In the appeal to the city manager, it really doesn't matter how that appeal comes out, because SB 2 is independent of any finding, correct?
That's exactly
Thank you.
correct, Board Member Doyle. The statute and Senate Bill 2, that statute I referenced, 13510.8, specifically says that regardless of what happens on an appeal or ultimate outcome of a termination decision by a local agency, it is of no import or consequence for the board or the commission to take action. The only exception to that is, and it's not true in this case, but there could be a circumstance where a agency has a hearing, that hearing concludes, and there's a finding based on that hearing. That procedure could have some collateral estoppel effect. That's a legal term that basically says, can you retry something that's been heard by another body? So that's the one exception. It's not applicable here. And so, you know, you said it much more succinctly than I, and I probably should have just gone with your interpretation, because that's correct. That is true. This board can proceed irrespective of what happens with any appeal.
Thank you. Yes,
One
please.
question. I wanted to ask the attorney, what law was he referring to that's not in place until 2026? I'm
Is
not
that
familiar with.
okay? Are you asking Corey Glaves that question? Okay, please, Mr. Glaves.
Yes, thank you. We've in researching for this hearing, we noticed that there was regulations by your board created, I believe it's December of 2024, and then Penal Code Section 13510.6, which goes into the standards for bias, is not operative until January 1, 2026.
And Madam Chair, I'm happy to comment on that if you'd like. Well, first and foremost, I'll have to go back and look at the statute Mr. Glaive is referring to, but it's really not important to look at it because it is not the authority upon which this regulation was adopted. This regulation was adopted based upon Senate Bill 2. The regulation was in effect prior to this case coming to post. And so the statute 13510.6, whether it was adopted in 2024 or not, I can go back and look, but either way, it's not the statute that resulted in this regulation. It's not relied upon for this regulation, and so it has no application to this case.
Thank you. Any other questions for Mr. Glaves or the attorney or Investigator Kong? Yes,
Or there's
Dr. Glazer.
a motion or further comment?
Right now,
I'm
it's
not going
just,
to make a motion.
okay, what I'm going to tell you is that there's also a caller on the line, so we have more.
I
So
defer.
just as to my question related just to Glaves, Attorney Glaves or the attorneys here or Ms. Kong, Investigator Kong. Okay. Thank you, Mr. Glaves, and we have another call on public comment.
Hi there. Hi, everyone. My name is Danny Sanchez. I'm a 19-year veteran in law enforcement, and it's been an interesting hearing today, especially this sort of hearing. I would like to add that this type of behavior is very, very common in law enforcement. It's also very common within law enforcement, within departments. Not only do some of us have to deal with employees who think this way, privileged employees, entitled employees, but we also have to deal with it when retaliation happens against some of us who are minorities who speak out. Like I said, it's a very, very common behavior. Public perception is very important. I mean, officers like this make the rest of us look like bad employees. And it's very hard to convince the public that we're doing the right thing when we have employees who behave in this manner. Now, to add to the comment from earlier in regards to clear and convincing evidence and the nexus between this behavior interfering with a person's career, there are many other ways that a person can act out when they have these kind of thoughts, and one of them is use of force. If a person has these biases, they will tend to act out in a more aggressive manner when it comes to use of force against a specific type of person or protected person. In my experience, I've crossed paths with employees who are biased, who seem to target only a certain group of people and who seem to be more aggressive with a certain group of people. Again, I think that the work that you guys are doing is great work, and it's very interesting. I appreciate what you guys are doing. I think that these things like this need to come out more often. I think that you guys are giving us officers who work in law enforcement the ability to report these kind of things whenever we come across them. This is something that didn't exist in the past, and a lot of times, we would basically say things to deaf ears and nobody would listen to us or hold anybody accountable for this kind of behavior. Again, it's a very common behavior. It's happened within the organization that I work with. It still happens. It's changed over time because of SB2 and because of the DOJ coming into departments and investigating them. It's changing this whole behavior. And again, thank you. I appreciate you guys. Keep doing the good work. Keep doing this kind of work. It's necessary. And this whole behavior in law enforcement, the wrong behavior in law enforcement needs to change. And it's changing slowly, but it's happening. And I want the public to understand that law enforcement has come a long way, considering how it used to behave decades ago. We are advancing little by little. We are changing. And again, it's time to root out all these people who have been destroying law enforcement for years. It's time to get rid of them. Thank you.
Thank you for your call. Very much appreciated. Any other public comment, either on the lines or here? Did I see a hand raised? Okay, it appears there's no further public comment. Would you like to, would any individual like to go deliberate privately on this case? Any member of the board? Okay, is there a
I'll make a
motion?
motion to certify Doyle.
Second.
Second, Laura. Okay, any further discussion, questions? Okay, would you take the roll call, please?
I just provide some discussion.
Yes, please.
One of my roles as an appointee on this board is as an academic. That's an official capacity that I serve, and I specialize my research in prejudice, discrimination, and hate crime. And I want to reflect on the evidence that we've seen and to say that the combination of image of blackface, of the very I don't even want to say insensitive, but the indifferent view of lynchings of Black men, and the approving response of the surrounding white men, and the subhumanization of Black men and the reference to the gorilla-like people. This is a recognizable pattern of bigotry that is quite potent and should not be dismissed by any means. I've seen this before, and it is quite predictive of behavior. I'm not saying that this officer engaged in biased behavior on the job, but this is not a trivial constellation of evidence. This is quite dramatic.
Thank you, Dr. Glazer.
So,
Yes, please.
I'm gonna, only simply because the NAACP name was used in your presentation, I do not want to taint anything, but my personal comment, as the professor said, this is what SB2 was built on, to outsource the officers who are taking this type of bigotry stance. And as a representative of the NAACP, I'm sorry, I'm in Paul, but I do not want to taint it. So therefore, I'm going to recuse myself so that I have confidence in my colleagues. So I guess I have to go outside during the vote,
No,
correct?
you don't
I
have to go
okay,
outside during the
good.
vote. But
Thank
you can, when the roll is called, you can then articulate what your position is, or just say abstain, or whatever you would like to do. If there was a discussion that you would ultimately make a decision on, then you would step outside. But since you've already said you're not making a decision, you can stay. Now, anybody else have anything else to say? So what we have is a first and a second. Yes, Mr. Johnson.
I'm just thinking, and I believe the attorney stated that in deed or in an action, there has been no demonstrable biases. So are we being asked to exclude text and words when a person utilizes those? I mean,
No.
according to the regulation, it states that we can consider the words
That's
in the
right.
text.
You can
And that's
cons-
what we're looking at today.
You can consider the words in the text. If I understood the attorney's argument, it was based upon the fact that there wasn't any discernible action beyond the words and the text. But absolutely, for purposes of your vote, you can consider the text because they're written, and written is part of the criteria. Thank you. Any other questions? Comments? Okay, we have a first, we have a second, we have had some discussion. Appears that there's no further discussion, so Chandler, please go ahead with the vote.
Thank you, Madam Chair. Plavo,
Yes.
Plavo, aye. Crawford,
Excuse myself.
Crawford recused. Doyle,
Yes.
Doyle, aye. Dudley,
Aye.
Dudley, aye. Glazer,
Aye.
Glazer, aye. Johnson,
Aye.
Johnson, aye. Laura,
Aye.
Laura, aye. Pena,
Aye.
Pena, aye. 7 yeses, 1 recusal, motion passes.
Thank you. Okay, just checking with the reporter. How are you doing? You're okay. Keep going. Okay. Then we're on to the last case. 1 moment, please. In matter of case of post 2305781, Blake Williams, who at the time of the events at issues in this case was employed with the Torrance Police Department.
No, wrong case. That's wrong. We just did now.
We just did that one. As soon as I said that, I thought, no, that's not right. Okay, now we're going to go on to Rogelio Rubilla. Thank you. In the matter of case post 230-9558, Rogelio Rubilla, who at the time of the events had issues in the case, was employed with Los Angeles County Sheriff's Department. Let's hear from, sorry, everybody, move this along. Okay.
It's just me again, ma'am. Law
Okay.
enforcement consultant, Robert Bringolf.
Nice to see you again.
Thank
It's been
you,
a
ma'am.
while.
Here to
And
provide a familiar face.
And counsel, would you please? take-
Counsel is Gary Woolley.
Okay.
Again, I'm one of the consultants assigned to the bureau that takes care of Los Angeles County for professional conduct. You've all met Carrie Woolley. I'm here today to present case 23-9958 involving former Los Angeles County Deputy Braulio Robledo. Of note, and as a point for your consideration, this case was originally assigned to law enforcement consultant Mark Evenson for investigation. About a month ago, Mr. Evenson left post to enjoy his retirement and time with his growing number of grandchildren. And as such, this case was assigned to me for presentation. So I'm going to try my best to answer questions related to the record provided by Mr. Evenson, but I may call on Ms. Woolley as she'd been prepping this case with Mr. Evenson prior to his departure from post. So that said, it's the division's determination that clear and convincing evidence exists to demonstrate that Deputy Braulio Robledo committed an act of serious misconduct as set forth in Penal Code Section 13510.8 when he lied to his supervisors and IA investigators about his actions related to a citizen's complaint of theft. Specifically, the division has determined that Deputy Robledo committed the following acts of serious misconduct. Dishonesty relating to the reporting, investigation, or prosecution of a crime, or relating to the reporting of or investigation of misconduct by a peace officer or custodial officer, including but not limited to false statements, intentionally filing false reports, tampering with, falsifying, destroying, or concealing evidence, perjury, and tampering with data recorded by a body-worn camera or other recording device for purposes of concealing misconduct. Just to be really clear, that's the entire statute. We're not saying he did all those things. So that's Penal Code Section 13510.8B1. I'll present a brief outline as follows. Deputy Robledo was hired by the Los Angeles County Sheriff's Department on March 11th, 2005. He was terminated from the Los Angeles County Sheriff's Department on August 2nd, 2024. Penal Code Section 13510.8C5 provides that the commission shall consider the peace officer's prior conduct and service record and any instances of misconduct, including any incidents occurring beyond the time limitation for investigation in evaluating whether to revoke certification for the incident under investigation. As such, there's a couple prior instances that we considered. The respondent has a prior sustained finding for dishonesty. On April 11th, 2023, the Los Angeles County Sheriff's Department found that the respondent violated department policy and procedures. Number one, sections 3-01030.10. I might just say that he violated some procedures, and if you want the specific ones, I'll just spare you me reciting numbers. Obedience to laws, regulations, and orders for misusing department resources to query a subject's name on the MDC, or the mobile data computer, for unauthorized and non-official business purposes. He violated some other sections for performance to standards by admitting to spending approximately 40 minutes socializing with 3 females while on duty in a secluded, dark parking lot and having a conversation which was personal in nature with one of the females, and admitting to using the MDC to conduct a wanted persons check on her ex-husband to verify if there was a restraining order. And 3, some other sections for dishonesty and false statements, and dishonesty or failure to make statements and or making false statements during departmental internal investigations. During his administrative interview with the IA Bureau, respondent contradicted his unit history report by stating he did not run the name of one of his female companions on his MDC on the night in question. The preponderance of evidence supported that the respondent did run the female's name on his MDC and lied about it during his IA interview. He received a 30-day suspension by his agency for that event. The agency reported that case to Post in April of 2023 as a possible violation of the dishonesty regulation. And on November 9th, we closed that case with a no further action because the conduct didn't meet the clear and convincing standard for serious misconduct for our division, and as defined in section 13510.8. On October 19th of 21, the Los Angeles Sheriff's Department undersheriff conducted an audit of misconduct investigations and found that the respondent had two separate investigations, one in 2018 and one in 2019, where fellow LASD deputies alleged he was a member of a law enforcement gang called the Banditos. Each incident involved a different deputy making the allegation. Based on that information, the undersheriff directed the agency to conduct an administrative investigation into the allegations. That investigation failed to substantiate the allegations and was closed by the agency on July 19th, 2024 as unresolved. We've discussed what unresolved can mean. Respondent received no discipline. The agency reported this case to Post on May 25th, 2023. So that the investigation was completed later, but it was reported to us on May 25th, 2023 as a possible violation of Post Regulation 1205A7, which is the participation in a law enforcement gang. That case is Post 2309109. On October 8th, 2024, Post closed that case with the status of no further action, or NFA, because there was no evidence presented by the agency or in the investigations to prove that the respondent was a member of a law enforcement gang. So we'll move on to the present allegation of serious misconduct. A citizen called the Los Angeles County Sheriff's Department East Los Angeles Station and stated he was stopped by an unknown officer in the early morning of January 2nd, 2020, immediately after leaving the Commerce Casino. During the stop, the citizen alleged that officer searched his vehicle and stole 5 poker chips worth $100 each. When asked directly by his supervisors, a sergeant and a lieutenant, if he had made the traffic stop in front of the Commerce Casino, respondent adamantly stated he did not. The Los Angeles County Sheriff's Department submitted this case to Post, in which they alleged Deputy Robledo was involved in serious misconduct when he lied to his supervisors and lied during an internal affairs investigation regarding the previously mentioned citizen's complaint, and that respondent conducted a traffic stop in front of the Commerce Casino and during a search of the vehicle stole $500 in poker chips. So after reviewing this investigation, the division has determined the respondent committed serious misconduct as defined in Penal Code Section 13510.8B1 and California Regulation 1205A1. That's the dishonesty section that I previously told you about. The respondent committed serious misconduct when he lied to his supervisors, when he denied any knowledge of a traffic stop that he clearly conducted just a few hours earlier, and he lied during his IA interviews when he claimed his supervisors never asked him about the specific traffic stop near the Commerce Casino. Deputy Robledo claimed he received information that supervisors were inquiring about a stop that occurred in Montebello, and Deputy Robledo claimed he deleted the MDC messages sent by the watch sergeant without reading them, and he claimed he never responded to the sergeant's MDC messages inquiring who made the stop. Deputy Robledo claimed he had no knowledge of why the watch sergeant was trying to get a hold of him, and he denied he called into the East LA Sheriff's Station and spoke to Deputy Strelo about the traffic stop in front of the Commerce Casino. The evidence overwhelmingly supports that the respondent did stop the complainant at Telegraph Road and Washington Boulevard and lied to his supervisors about the traffic stop. The evidence also overwhelmingly supports that respondent lied to the IA investigators during his IA interview. While investigating a citizen's complaint alleging that the officer stole $500 worth of poker chips, supervisors asked the respondent if he had stopped the complainant around the Commerce Casino. He adamantly denied he was the one who stopped the vehicle. This conversation took place approximately 3 hours after the time of the traffic stop. There is indisputable evidence that the respondent was the one who conducted the traffic stop. This evidence includes a unit history report showing that the respondent ran the complainant's license plate, a GPS tracking report showing the respondent stopped his vehicle at the exact time and location alleged by the complainant, and video surveillance footage confirming that it was the respondent's patrol car making the traffic stop. The respondent later admitted to making the traffic stop during his IA interviews. Respondent claimed to supervisors that his supervisors never specifically asked him about the stop in front of the Commerce Casino and assumed they were asking him about a stop that occurred in Montebello. These statements are refuted by clear and convincing evidence. Another allegation is the respondent lied to IA investigators when he stated he did not know his supervisors were asking about a traffic stop that occurred in front of the Commerce Casino. During his IA interviews, respondent tried to claim that he had no idea that his supervisors were asking him about the traffic stop in front of the Commerce Casino. The evidence supports that this is a false statement. Both the watch commander and the watch sergeant made it abundantly clear that they were inquiring about the specific stop that occurred in front of the Commerce Casino, and there was no question that the respondent understood which stop they were referring to. There is no reason why the watch commander and watch sergeant would lie in their statements, and their statements are more credible than the respondent's in this case. The respondent received 2 MDC messages from the watch sergeant inquiring about a traffic stop in front of the Commerce Casino around Washington Boulevard and Telegraph Road. The first MDC message was sent to 3 deputies that were working in the City of Commerce to include the respondent. It stated, "Did any of you stop?" And then we redacted the complainant's name at Washington/Telegraph earlier at, and then an ellipses and end quotes. 2 other deputies replied immediately, but the respondent did not respond. The second MDC message was sent directly to the respondent and said, "Did you pull over the complainant at Washington Telegraph a few hours ago?" Again, he didn't respond to the question. But approximately 12 minutes after receiving the second MDC message, the respondent sent the watch sergeant an MDC message that says, "Called you, Sarge." This provides clear and convincing evidence that respondent did receive and read the sergeant's MDC messages and was fully aware of what traffic stop his supervisors were inquiring about. Respondent's refusal to answer the sergeant's MDC messages supports the conclusion that respondent was being deceitful and trying to hide the fact that he was the one who stopped the complainant in front of the Commerce Casino. The respondent's claim that he had no idea what traffic stop his supervisors were asking him about is further refuted by the fact that approximately 35 minutes prior to meeting with his supervisors, he called the East LA station and spoke to Deputy Strelo on a recorded line. Deputy Strelo told respondent that the watch sergeant was inquiring about a stop in front of the Commerce Casino. This provides clear and convincing evidence that respondent knew exactly what traffic stop he was being asked about during his meeting with supervisors. Respondent's claim during his second IA interview that he did not remember the conversation with Deputy Strelo is not believable, particularly as the respondent was able to provide details about a conversation he claimed to have had with Deputy Palacios earlier during that same shift about a different stop allegedly in Montebello. Further, the respondent lied to IA investigators when he stated he received information that supervisors were inquiring about a traffic stop that occurred in Montebello. During his IA interviews, respondent tried to claim that he didn't lie to his supervisors because he thought they were asking him about a stop that occurred in Montebello. It's already been established that based on the supervisor's testimony, the MDC messages, and the respondent's phone conversation with Deputy Strelo, that he knew his supervisors were inquiring about a stop in front of the Commerce Casino. When asked by IA investigators why he thought they were talking about a stop in Montebello, he said he received 1 or 2 MDC messages inquiring about a Montebello stop. He also claimed that he called Deputy Manuel Palacios on his cell phone, and Palacios told him that someone was calling in about a stop in Montebello. Respondents' statements are refuted by indisputable facts. 1, there's no record of any MDC messages being sent out about a stop that occurred in Montebello. And 2, when Deputy Palacios was interviewed, he stated he had no recollection of a phone conversation with the respondent. There is clear and convincing evidence to support the conclusion that respondent created a narrative about a fictitious Montebello traffic stop to cover up the fact that he lied to his supervisors and to disingenuously claim to IA investigators that his previous denial to his supervisors did not constitute dishonesty because he allegedly believed they were asking him about a stop in Montebello. However, the clear and convincing evidence shows that respondent lied to IA investigators when he claimed he received MDC messages about a Montebello stop, when he later claimed that Deputy Palacios gave him information about a Montebello traffic stop. Outside of the respondent, no one else had any knowledge of an alleged traffic stop in Montebello. The respondent lied to IA investigators when he stated he was not aware the watch sergeant was trying to contact him. The respondent told IA investigators that he was not aware that the watch sergeant was trying to contact him. This statement was refuted by indisputable facts. 1, the respondent sent that message that I discussed to the watch sergeant on the MDC that said, "Called you, Sarge." This message was sent approximately 12 minutes after the respondent received a direct MDC message from the watch sergeant asking if he had recently stopped the complainant in front of the Commerce Casino. 2, during his recorded phone conversation with Deputy Strelo, respondent stated he and the other Commerce units received a text from the watch sergeant. This provides clear and convincing evidence that respondent lied when he said he was not aware that the watch sergeant was trying to contact him. The respondent lied to IA investigators when he stated he deleted the MDC messages from the watch sergeant without reading them. The evidence clearly proves the respondent did read the MDC messages from the watch sergeant. As we discussed, approximately 12 minutes after receiving the watch sergeant's second MDC message, he sent an MDC message to the watch sergeant saying, "Called you, Sarge." 2, during his recorded conversation with Deputy Strelo, respondent told Strelo that he and the other commerce units received the text from the watch sergeant. This provides clear and convincing evidence that the respondent lied to IA investigators when he stated he deleted the sergeant's MDC messages without reading them. The respondent lied to IA investigators when he stated he never responded to any of the sergeant's MDC messages. Just for clarification, I just want to put to the point here, I am reciting each instance of an act of dishonesty. So there are certainly some of these that overlap, and I'm noticing that I'm sounding like a broken record. So bear with me. We're just making the point to each one of these instances of dishonesty. Approximately 12 minutes after receiving the watch sergeant's second MDC message, respondent replied via MDC stating, "Called you, Sarge." This provides clear and convincing evidence that respondent lied when he stated he never responded to any of the sergeant's MDC messages. Respondent lied to IA investigators when he stated he never called the East LA station and spoke to a deputy on a recorded line regarding a traffic stop in front of the Commerce Casino. As we've discussed, that was a recorded conversation. So the facts that I've just recited support the division's finding that Braulio Robledo was involved in serious misconduct, specifically dishonesty. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Mr. Robledo's post certifications be revoked, and the division's recommendations based on the clear and convincing evidence that the respondent lied to his supervisors about the traffic stop and subsequently repeatedly lied during his IA interviews. The facts fully support respondent knew exactly which traffic stop his supervisors were inquiring about and lied to them about his involvement. In addition, respondent lied several times during his IA interviews when he, number one, stated his supervisors never asked him specifically about the traffic stop he conducted in front of the Commerce Casino. 2, stated he was not aware that the watch sergeant was trying to contact him. 3, stated he deleted the MDC messages from the watch sergeant without reading them. 4, stated he never responded to any of the watch sergeant's MDC messages. 5, stated he received MDC messages about a stop in Montebello. 6, stated he was told by Deputy Palacios that there was an inquiry being made about a stop that occurred in Montebello. 7, stated he did not call and speak to Deputy Strelo. And 8, stated that no one gave him information that the watch sergeant was inquiring about a stop that occurred in front of the Commerce Casino. With that, I'm happy to attempt to answer any questions that the board may have regarding LEC Evenson's case.
I just have a couple of, I think, quick questions. It seemed to me in my initial reading that there was another prior instance in which he lied. Was there first, aside from the 3 you mentioned, was there one even before that?
That's unclear, ma'am.
Okay.
I cannot specifically answer that question. I don't know if Carrie can, but
I can answer that question. Yes, so there's an earlier case in which he lied. And if you look at the timeline for LASD, what happened is they did do an investigation about an earlier dishonesty case and they did sustain it. Post did not decide to move forward on that. They issued a finding that there was not clear and convincing evidence, so it's not before this board. There were some evidentiary problems with that case. The witnesses took about a year to come forward. There was some delays there. So that's why it didn't meet the clear and convincing standard.
Okay. Just because I didn't want to do any independent investigation, what's the approximate distance between Commerce Casino and Montebello?
It's about a 10-minute drive.
Okay.
But it looks significantly different.
I understand.
Yes.
Did he ever indicate that there was another reason why he typed the words "called you, Sarge"? No. How did the respondent / civilian / victim know about the gang allegation? Do we know?
Yes.
Okay.
So to give you a bit of background information on this, because there was an allegation that Deputy Robledo had stolen from this victim, the Los Angeles Sheriff's Department referred this to the district attorney for a criminal investigation. And when they did that, the district attorney's office attempted to contact the victim for further information and cooperation. During that time period, the victim had seen a Los Angeles Times article which named Deputy Robledo as one of the deputies that was involved or was a member of the Banditos law enforcement gang. In addition, that victim has a brother-in-law who is a Inglewood police officer.
I saw that in the notes.
Yes, and had said that Robledo apparently was some sort
Okay.
of gang
I was
member.
just wondering if he got it from his brother-in-law, whether he got
Correct.
it from some newspaper article, but I now understand.
Yes.
Now, I was a little confused about the MDC messages system in general. And I'm a little confused about what he said. Did he say, and I thought, I read these words, but I don't know if it was out of context, that he never reads the MDC messages?
That's not how I interpreted the.
But there was a
his statement.
sentence that he said he never reads them. No?
He-
Okay.
Yeah, in his transcript, he says both. He tends not to, but then he also said he did not on this particular date. And then at some point, he also said he was having difficulty with his MDC messages on this particular date. Yes.
Does he have a duty to read his MDC messages?
There's no policy on point on that we're aware of.
Is there any proof either way that the MDC wasn't working that day during that time?
What we have on point for that is that he is on a recorded conversation with Deputy Strello referring to these MDC messages that he received. Telling Deputy Strello that he received those those MDC messages, and also that he then successfully sent an MDC message back to the watch sergeant.
So my question was, maybe I wasn't clear, was there any evidence that the MDC system wasn't working
There's no evidence that it was not working that day. That's correct.
at all?
It may have been sporadically not working, but at the times that those MDC messages that are at issue were sent, they appear to have, the system appears to have been working.
And is there any, with text messages, you could certainly, unless they've been deleted and they're gone forever, find proof that something went out and find proof, sometimes it says delivered at the bottom. Is MDC set up like that?
I've used MDCs with different programs and there's
Right.
different vendors. And so without, I wouldn't be able to answer that specifically. The one indication on here, he says that his MDC was in the red. Just my own experience as somebody who's used an MDC in a pretty rural area, sometimes those things go in and out of service. There could have been something that caused that. I mean, again, this is a bit of supposition, but he could have just been out of service and those things could have delivered again once they came into service. That's one way it could be out, or it could be a network failure, right? So it's hard to say, and it's we don't know specifically which.
What does MDC stand for?
Mobile data computer.
Okay, and so what's the difference between an MDC message and a text message?
Text message would be done through a phone, at least colloquially, how we call a text message. But you could say in an MDC that you're getting a text, because an MDC is essentially just a laptop computer or an analog, and it has a program running that you can run CLETS inquiries through. You may have a mapping program on them, and it may have a texting program where you can send text messages. So it would not be unreasonable to say that sending a message, a written message over your MDC was a text, because it is a texting function of that MDC.
I believe that at some point there was some discussion that there was a transcript or there was a recording of the phone call that he made into the station. Okay, did I understand this correctly? When the receiver of that call, that was a recorded line, and he said later that he did not remember the call? Is
I
that
said that
correct?
it didn't happen.
Didn't happen. Okay, and then, I'm not, no, let's get our keys straight. I'm talking about the other person on the phone. He was interviewed.
Different person.
Right.
Different person. So
Right.
that there's one conversation to a Deputy Strelo on a
Right.
recorded line,
Right.
another conversation to a Deputy Palacios.
Right.
Who
Palacios
said
was at the
he
station.
didn't remember
Okay.
talking to.
So Palacios was at the station. Stilo was when he was still in his car or someplace away.
That's not how I understand it.
So let's just focus on
Sure.
the recorded statement.
Mhm.
So was there a recording and who was it between?
So the recording is with Deputy Strello, who was working dispatch at the time. He's a deputy sheriff, but he's working dispatch, which happens when they're unlimited duty
Right.
usually. And it was with Deputy Robledo. So Deputy Robledo called into the station. He got Deputy Strello, who's working dispatch. It's a recorded line because dispatch is always recorded. And that's the call, that's the recorded call. And during his IA interview, Deputy Robledo said he did not call into the station and speak to anybody. He repeatedly denied that. They then played the recording for him. And then at that point, he said, I do not remember that call.
So the he who did not remember was,
Deputy Robledo.
okay,
Yes,
thank you.
you're welcome.
Okay, so other questions? Yes.
Just maybe not a question, but an answer about MDCs and how they work. If you're looking for indicia of a system working, the systems that we use, that if he's successfully running a subject on the car computer, it is indicative that the computer system is sending and receiving information because they're all on a related trunk. Also, that he said that he sent and received messages is other indicia of it working. And then the vehicle tracking system also placing him at the place where the traffic stop was made is other indicia that that system is operating successfully, and particularly so at the operative time.
Also, Madam Chair, you were, I don't know the distinction between a duty and a responsibility, but a lot of agencies use MDC to dispatch lower priority calls. So I don't know if there's a difference between duty and responsibility, but you certainly have a responsibility to respond to the MDC.
Thank you. Other questions or comments for the? No? Okay. Before we get to the public comment or the comment from Mr. Bello or his attorney, we're going to take a break. This will be our last break. It's now 3:04. If everyone could be back at 3:15, that would be terrific. Thank you. And we've had our last break. And let's see. At this time, does the subject officer and/or counsel wish to make public comments? If so, you'll each be given 4 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented during division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following: if the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulations 1205 occurred? Is there anyone from the public who either, there you are. There's someone on the screen. Please introduce yourself.
Thank you. My name's Elizabeth Gibbons, and I am the attorney for Deputy Robledo. Thank you. I thank you for giving me the opportunity to address you about this very important case. A couple of things that I wanted to address first with regard to the questions that you had asked. The city of Montebello, I don't believe, is 10 miles away from the city of Commerce. And that's not to nitpick that, but the significance of it is that Montebello is directly adjacent city. So the city of Montebello borders on the city of Commerce, but the city of Montebello has a separate police department. So when Deputy Robledo was concerned or believed that he was being asked about a traffic stop in Montebello, his reaction to that was, well, I didn't stop anybody in Montebello because that's not my jurisdiction. So there wasn't any issue about any misconduct related to the stop in Montebello. That was just information that he had that frankly just confused him that night. The incident that we're talking about happened in the 15th and 16th hour of Deputy Robledo being on a double shift that day. So this was the end of a double shift for him. When he stopped the gentleman from the casino and conversed with him, talked to him, searched his car, it was a lawful search because that gentleman's registration had expired. So there was no misconduct involved at all in conducting the traffic stop. He asked for and obtained consent to search the car, and he searched the car pretty rudimentarily because the car was clean. The driver of the car had been very cooperative with him. There was nothing that set off any bells or whistles for Deputy Robledo that there was any problem with the person that he stopped. So he looked through the car, but he didn't thoroughly search it. He let the driver go with just a warning about the registration. He didn't cite him, he just let him go. So in Deputy Robledo's mind, there was nothing about that traffic stop that his supervisors would be asking him about. He didn't anticipate that the person he stopped would have made a complaint or anything like that. He didn't look in any bag. He didn't know the man had any money with him. And he did not steal any poker chips. There's no evidence that he stole the poker chips. With regard to the complainant's later assertion that he didn't want to go forward because he feared that the banditos, there never ever has been any published LA Times article that says Deputy Robledo is a member of the banditos. He is not. That allegation is completely, entirely false. And the Sheriff's Department supervisors have recognized that. What he said was, my brother who works in Inglewood Police Department told me not to go forward because there are banditos. He never said he was afraid of Deputy Robledo. He in fact said he couldn't even identify Deputy Robledo. Under the regulations,
Let me just tell you, you're at 4 minutes, but I'm going to give you another minute, okay? But this is public comment limited, but go ahead, please.
I appreciate that. Can I take Deputy Robledo's 4 minutes away from him? Sorry, that's just a little attempt at humor and I'm wasting my time. So Deputy Robledo never stole any poker chips. The definition in the regulation of false statements to be a violation or to be significant misconduct under the post statute requires that the statements be made for the purpose of preventing the detection of misconduct. And he engaged in no misconduct in relationship to this traffic stop, either the stop itself or the alleged theft. He didn't do either one of those. With regard to the allegation that he lied about saying he didn't remember the phone call with Deputy Strelo, or he didn't read the text message or the MDC messages, the fact of the matter is he wasn't questioned about this, about the MDC messages, about Strelo, about any of that until 4 years after the fact. This incident happened in January of 2020. He wasn't interviewed by IB until December of 2024. He wasn't shown the MDC messages before the interview. He wasn't played the phone call until the second interview, which was 6 weeks later. So his failure to recall these details is not the same as intentionally, knowingly lying about them. All that he did was fail a memory test that the Sheriff's Department gave him 4 years after the fact. And he couldn't remember the details of who he talked to or who he called. But he very, very clearly said, when he was asked by IAB, did you see these messages from the watch sergeant? He said, no, I was out of my car. He never said, I routinely don't read messages. I just didn't read these messages. He said, I was outside of my car. It was the tail end of my double shift. I was hungry. I was eating dinner and I was writing a report. So he did not see those messages. He also said very clearly in his interview that Deputy Palacios called him and told him, hey, the watch sergeant is looking for you. And he said, why? And Roblato said, why? Because he didn't read the messages. He wasn't aware of the messages. It was in response to the phone call from Palacios that he called the station, which he didn't remember doing. He didn't even remember doing that. Even after they played him the message, the recorded message, he didn't remember doing that. But his MDC message that says, Sarge, I called you, was in response to the phone call from Palacios. It wasn't in response to him seeing the MDC messages. So
Yeah, I understand. Thank you. Other board members may have questions. Let me just pause. I believe your client also wanted to speak. And we'll see if the board has any questions for you, or you can wait until we'll see if they have questions after your client speaks. What would you like us to do?
I don't think that he wanted to add anything, but Braulio, do you want to add anything to what I've said? You
I'm
can
not
if you
sure
want.
you could hear me, ma'am.
I'm
Yes,
sorry.
we
Go
can
ahead.
hear you.
Yes.
Yeah, no, first of all, I appreciate you guys here, and obviously I appreciate Miss Gibbons always being there for me. Um, but yeah, it's just I was never given that information when I went up to the watch sergeant's office, let alone when he took me into the Lieutenant Easter's office. The other important thing that I want to shed light on is the fact that the same thing that Manny Palacios had mentioned to me, saying this gentleman, I was on the phone with him for about 40 minutes. He doesn't know where he got pulled over. I'm trying to figure it out from him. He's giving me uniforms from blue over blue, tan over tan, which are CHP officer uniforms and different agency uniforms. He's mentioning the 605 freeway, which is about 15, 20 minutes from East Los Angeles. And then also the Montebello, which is the closest city to where I was working. And that's the reason I attached myself to Montebello, because obviously that's the closest to East LA Commerce. So I said, no, there's no reason why I would stop anybody in Montebello. So he's like, yeah, I'm just trying to figure out where this guy got pulled over. So I was under the impression at that moment that that's what the complaint was about. So when I went up to my watch sergeant's office, all he said, well, it was you. And I said, it was me. What, Sarge? I didn't pull anybody over in Montebello. He's like, no, 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 come with me. When we stepped into my lieutenant's office, he's like, oh, look, it was Robledo. And I told my lieutenant, what's up, lieutenant? I said, am I good or what's going on? He reiterated everything Manny Palacios had said. He's like, don't worry about this, bro. He's like, this guy doesn't even know where he got pulled over. He's talking about blue over blue, tan over tan. He doesn't even know what uniform personnel pulled him over. And I asked him again, I said, so am I good, LT, or what? And he said, you're back for PM shift, right? And I said, yes, sir. And he's like, yeah, get out of here, get some rest. He says, you only have a couple hours before you get back. And I said, okay. And I left. And that was the last I had heard in regards to this matter until maybe a couple months later, where ICIB showed up at the station. But my whole thing that night, like Miss Gibbons said, I had no issues with that gentleman. It was just a simple expired registration stop for about a month. The car was clean. There was no debris anywhere. It was a fast, quick stop. And I let him off with a warning, which he was very appreciative of. And that was the last I had contact with that gentleman. And that was it, man, sir.
Hello, you said that you had this conversation and it ended with go home, bro, and get some sleep. And then you said something about a couple of months later. I thought your attorney was saying 4 years had gone by, so I'm confused. And we
My
can let your
my
attorney, hang on, We can let
Okay.
your attorney respond to that question or you.
I'll respond to it, Braulio. So what happened was, immediately after the incident, he went home, he came back to work the next day. He worked for 4 months without any problem. About 3 or 4 months later, ICIB came to the station while he was still working regular duty. And they asked him, we have this allegation, do you want to talk to us? And he said, no, I don't want to talk to you without my attorney. So we didn't make a statement to the criminal investigators. When he was asked any questions about any details about the incident was 4 years later in December of 2024 when he was interviewed by IAB. So I didn't mean to confuse you about that, but he didn't make a statement to the criminal investigators. And the other thing was that he wasn't relieved of duty by the sheriff's department immediately after the conversation with the 2 supervisors that they later said he lied in. The fact
All
when
right, you answered my question. You had said something about 4 years. He had said something about 4 months. We have the information now. Let me see. Does any board member have any questions?
Chair Dudley, may I make a clarifying
Yeah.
comment? So Mr. Robledo was actually terminated from his employment in August of 2024. His interview did not happen in December of 2024.
Okay.
I'm trying to locate the date, and once I locate the date, I'll let you know.
I think it was December 2023. I apologize. It was 4 years after 2020, from January of 2020 to December of 2023. I apologize.
Okay. Any other questions for any board members? Yes, Ms.
I have one. I'm just curious. What was what caused you, if you pulled him over for expired tags, why did you search the car?
I usually search vehicles. It's common in where I work at. We search vehicles obviously to make sure that everything's okay. He had expired registrations, and there was a different name also on the registration, which was his cousin. So I just wanted to make sure everything was valid for him and there was no weapons, nothing visible that I could see. Usually with someone that's cooperative like that and it's a clean car and I get a good rapport. I've been on the streets at that time on patrol about 10 years. So I kind of get that feeling of, okay, this guy's very cooperative. This is just uh, we don't like to call routine traffic stop, but it was just a simple traffic violation, traffic stop. So there was nothing for me to pursue looking under anything or anything of that nature, ma'am. Um, but I had asked him, I said,
So let me ask you, just to clarify the question that's been asked of you. Is it your habit when you're stopping someone for registration, is it your habit or your training to search the car? That's the
yes,
question that was asked
because
of
I
you.
had asked him if there was anything illegal in the car. Is it okay if I search your vehicle? He said, no, that's not a problem. Everything's fine. Go
So
ahead,
is
sir.
it your habit or your training to ask for consent in every situation where you're looking for, where someone has an expired registration?
Yes. To me, it's my habit to do that, ask for consent. I always have to ask for consent, unless I see something in plain sight that's illegal. Unless obviously if I believe the person's under the influence of narcotics or some type of substance where I know I need to bring them
Okay,
out
I'm
of the
just checking now to see if a board member has a follow-up question to that.
I do. Thank you, Chair. Is it policy or is it supported by law that you pull someone over for expired tags and you ask for consent to search the vehicle?
It always has to be consent as far as searching the vehicle, ma'am. Like I said, obviously, if I see something in plain sight, if I see drugs in plain sight, I'm not going to ask for consent because now my detention is going to start turning into something more to see if there's something else that might be illegal or if he's transporting anything of that nature. But my common
Question that
practice,
was asked of you was, is it your habit or is it part of your training that
yes,
when someone has, hang on, when someone has an expired registration, do you ask for consent and search their car? So it's not a question of did you ask for consent or do you, but is it your habit or your training to ask someone for consent if they have an expired registration?
Yes, both. It's through my training that I've gone through and my habit after 10 years on patrol
Okay,
to
any
ask for
follow-up
consent.
questions?
Yes, he still didn't answer my initial question. Is it supported by law or is it policy of your agency that you search vehicles for a expired registration stop? You stated yourself that nothing seemed out of the ordinary, nothing was suspicious, you didn't smell anything, you didn't see anything in plain sight. So is it supported by law? Is it supported by your agency's policy that you search vehicles behind a expired registration?
Yeah, it's both, man. It's an expired vehicle that should not be on the road. So it's against the law to be driving a vehicle that has expired registration. So it is by law.
Okay.
And then it's common practice for me to be asking for consent also.
Thank you. Anything follow-up, or Laura would like to speak?
No, he didn't answer the
I
question
know.
still.
If I could try to answer that question. And
One
explain-
moment, I'm going to stop you and I called on a board member. Go ahead.
Just so it's clear, it is not illegal to ask for consent, even from a person I consensually am having a conversation with, say at a Starbucks or in any context where if I'm chatting with somebody, it is legal to ask a person for consent. My agency goes beyond the law, which requires the person to say yes or no, understanding the rights. We go a little further, say you can withdraw. You don't have to say yes. You can withdraw at any time. They have to be present while I'm conducting the search to reduce the scope or end it, even after the search has begun. But as a matter of law, it is perfectly legal to ask a person during a consensual contact or in a vehicle stop. It's a detention based on reasonable suspicion. The reasonable suspicion being the expired registration. It can be done even in the absence of any particularized suspicion. That's the nature of the law on that.
I don't think the question's been, can you ask for consent? The question's been, in situations like this, where someone has an expired registration, does that compel you to ask for consent? Not, anybody can ask consent about anything. Do you understand the distinction?
Yes, I just thought it would be useful to understand that there's nothing untoward in asking.
And I didn't think that.
I know. Yeah, okay, yes.
And I think, to go along with Board Member Nicole, as he said routinely, that he will ask permission to search a car based on expired tags. That's concerning to me. I know you were polite, Board Member Nicole, about it, but it's concerning that this was a routine of a stop. Although, to your point, Captain Laura, that it may be routine, is still concerning to the community. And a lot of times people are afraid to say no. It's just my comment.
Thank you. Any other, yes, Mr. Johnson?
Johnson. There are prior allegations of dishonesty. And for the division, help me understand the prior allegations of dishonesty compared to where we're at today in the past. And also the fact that the defendant or the person that claimed he had stole the $500 worth of chips gave a statement that, and they tried to twist the words maybe, but that he belonged to a gang called the Banditos. And I'm reading that 2 officers also alleged that he belonged to this gang called the Banditos. So could we get clarity on both of those?
Sure. Help me understand what clarity looks like so I can provide it.
These officers alleged that he belonged to Banditos.
Okay.
I think the attorney said that it wasn't that the person that he stopped and alleged that he had stole his Chips said he belonged to the Banditos, but he was afraid of the Banditos. So there's a question on whether he said that he felt that he belonged to the Banditos because his uncle or cousin, whoever's with the police force, knows that and stated to him, and he repeated it. And so I just wanted to make sure we got clarity that it sounded like they're saying that he didn't say he belonged to the Banditos, but he's got a history of being alleged to belong to the Banditos.
So there were two cases that the undersheriff of LASD found in which the respondent was alleged to be a member of the Banditos. Those cases were filed by two separate deputies. I don't know the relationship to Deputy Robledo. There was no information in the record or in the reports provided to Post with that allegation that substantiated the claim that Mr. Robledo is a bandito. So in that case, there's no evidence to support that allegation. As far as the previous dishonesty case, there is a agency finding of dishonesty and of policy violations related to dishonesty, and I believe an agency finding of I think there's an agency finding of dishonesty. That dishonesty finding was provided to Post, and we did a independent investigation, and we were unable to make, we were unable to bring that allegation forward with a clear and convincing standard. So there was likely a preponderance standard of evidence that would allow the agency to make a affirmative finding of dishonesty, but we as the division were not able to reach clear and convincing evidence as a standard. So that case was closed at Post with no further action. So there is a prior dishonesty allegation. There's a prior dishonesty finding at the agency level. And there are two prior allegations at the agency level that Mr. Robledo was or is part of the Banditos law enforcement subgroup or gang. So is that helpful in clarifying? So we don't have any cases that we can bring forward with those allegations substantiated.
Right, so if I'm understanding the law right, clear and convincing evidence. So there has been allegations made, but nothing that was sustained. Is that what I'm hearing?
There were allegations that were sustained on dishonesty. Those were sustained at the agency level. So we were not able to reach a clear and convincing standard of evidence to present those and make a finding of dishonesty by our standard. So our standard being a little bit higher than the preponderance standard. Post takes no issue with the findings. We don't have any comment on the findings. They seem to be appropriate, other than they seem to be appropriate at the agency level and under the preponderance standard of evidence.
So the last part, when he made the stop, it says that it was either in front or next to the Commerce Casino. And I'm sure that him being a patrol officer in that area knew where the casino or what city it was located in. And if I remember reading it correctly and hearing it right, he alleged that he didn't know he was in the city where the casino's at, and he stated that he was in a different city. Is that correct?
That's not how I interpreted the record. No. No, that's not how I interpreted it.
Thought I heard.
I think Mr. Johnson, tell me if you heard it this way. He never said that he was in Montebello. He said people were asking about Montebello. He felt he was not in Montebello at any point. Therefore, he didn't think the questions are relevant to him.
That is how I understood it as well, Chair.
Yes.
I have a question.
I want to make sure. Mr. Johnson, anything else for now?
No, that's good.
Okay, thank you, Mr. Lar.
So I have a question in point of clarity for the either the Officer Robledo or his counsel. I am hearing two things that I want clarity on. One, I understand that the Officer Robledo was at the end of a double shift. I've worked double shifts. I understand that. I'm curious as to why Officer Robledo has clarity with regard to items that are complementary to his situation but has a lack of clarity with regard to anything that pertains to accountability. So I just wanted to see why the clarity level is different given the end of the same the double shift, and the things that are not complementary to his case seem to be a little murkier.
So I'd be glad to answer that for you.
I'm going to give you 1 minute for that answer because you're given 4. I've already given you 6. You've been asked a question, but you've got 1 minute. Thank you.
Thank you. The only thing that Deputy Roblato didn't remember from the incident that happened 4 years ago when he was interviewed by IAB was the phone call with Deputy Strelo. He didn't remember that happening at all. He was never shown the MDC messages. I would also mention that the Sheriff's Department, and in the documents that were provided by the Sheriff's Department to the board, they did not provide you with all the MDC messages from that shift. So there's no evidence to say there was no MDC discussion about Montebello. The only thing he didn't remember was that phone call, which was less than 15 seconds long, and in which he was told the sergeant wasn't there. So there wasn't anything memorable about that conversation that would have stuck in his head. Whereas the conversation with Palacios, he didn't remember that initially, but as they kept asking him questions in the interview, it came back to him. But he didn't remember, even after they played it, the 15-second or less conversation with Deputy Strelo. So that's the only reason why, because the conversation with Palacios became significant as they asked more questions.
Okay. Okay. Thank you. Board Member Lahr, do you have any further? Okay. Anybody else have any questions for Mr. Bello or his attorney, Mr. Glazer? Board Member Glazer, no? Okay. Thank you both. Is there anyone else that has public comment on this case? On the phone here? Okay, thank you. Thank you very much for appearing. Thank you, Mr. Bello.
Thank you, ma'am.
Okay,
Thank you.
so you're welcome. So now, deliberation? You guys want deliberation? Okay, here we go. Let's go deliberate. Okay. We will now reconvene at regular session to take a vote
I think we're
in the
missing.
matter.
We're missing.
Oh. Oh, he's not over there. Okay, we're gonna wait. Mr. Johnson's not quite back yet.
Yeah, the other room was one.
Okay, back on the record. In the matter of case post 2309558, Virgilio Robeldo, who at the time of the events at issue in this case was employed with the Los Angeles County Sheriff's Department. Does anyone want to make a comment at this point, or does someone want to make a motion?
I'll make a motion. I'll make a motion that the board would like more information, because we all seem to be, so it's just not me, so that we all seem to be confused on things. Now, I can't speak, all of us might have something different, but in terms of just as about interviews, when.
Okay, before we get to what we want, let's just do the motion first.
The motion is that the motion for more information before we make a final decision.
Is there a second? Okay, roll call, please.
Clavo,
Aye.
Clavo, I, Crawford,
Aye.
Crawford, I, Doyle,
Yes.
Doyle, I, Dudley,
Aye.
Dudley, I, Glazer,
Aye.
Glazer, I, Johnson, Johnson, I, Lara,
Aye.
Lara, I, and Pena.
Aye.
Pena, aye. Motion passes unanimously.
Okay, so that motion. Um, So go ahead and speak into the record.
And so just to interpret the intent of this motion and what would actually happen in relationship to this particular hearing, I think what we're talking about is a continuation of this hearing and that certain items would be investigated or details provided to the board to make a final conclusive determination. Is that fair?
That's correct.
Um,
That's fair.
Yes, that is fair. And let me tell you the second part, and then you can hear that. There was confusion on several issues. And what I had assured the board when we were discussing this was that each one of them could talk about the issues they're seeking further investigation on, so that the motion didn't have to include all of that. So as we understand the motion now, we are asking for a continuance of this matter. We are asking for further investigation as to the continuance, and we could explain what it is we'd like, but go ahead.
So just a matter of authority of the board. The board has the jurisdiction to recommend to the commission that the division conduct further investigation. So you would actually be making this recommendation to the commission, to direct the division to conduct further investigation. You can also line out what you would like clarified, but that is your recommendation before the commission. Okay?
Okay, so if that's what we can do, then it is not a continuance.
No.
We're never going to see this case again.
Okay.
What we're going to do is ask that the board request further investigation. Then we're going to articulate for the record what further investigation would be helpful to us. Is that correct?
I believe the commission can, if they so choose, after granting, if they agree that there needs to be further investigation to complete the record, the commission could allow the board to hear this matter again. But at this point, the recommendation before the commission, it just remains to be seen what the commission is going to do with that recommendation. Does the division conduct additional information to bring the case back? Whether the commission says it needs to go back through the board or go directly to the commission, they can make that decision. Yeah.
Yes.
Just a question, and maybe this information is readily accessible. And so I would just like to pose the question. For us, well, for me, I'll speak for Nicole. There was confusion on timelines. And so the offense occurred on January 2nd, 2020. We know that the attorney alluded that 4 years had passed prior to this being brought forth to the what's his name? The
Before he'd been
officer.
questioned.
I'm sorry. The officer. Do you all know if it was from 2020 to 2024 before he ever was interviewed, talked to, spoke with about this case?
I can answer that question. So because there was an allegation of theft, the Los Angeles County Sheriff's Department made a referral to the district attorney's office. And as part of that, they did a criminal investigation. Mr. Robledo was offered, or they attempted to interview him as part of the criminal investigation through the Los Angeles County Sheriff's Department. He declined to be interviewed. That would have been in 2020. What happens when this sort of an incident occurs, when there's a criminal allegation made, they will conduct the full criminal investigation, see if the district attorney is going to file charges, and then it's not until the DA either files charges or declines to file charges that they pick back up the administrative investigation. That's what happened here.
So explain the 4 years.
No, 3 years went by.
Okay, so 2020 was the offense. It was then sent to the DA's office to make a decision about
Yes.
whether to file charges. And then it wasn't until when that he was interviewed?
It was in 2023. He was interviewed on or about December 14th, 2023 for the first interview.
So that's almost 4 years. We have
Correct.
February of 2020, then we have December of 2023. So that February would have been, those 2 months later would have been February 24, so it would have been almost 4 months.
Correct.
Okay. Does that answer your question? Okay.
I believe so. Well, one more clarifying question. So for my own edification, is my understanding that because the DA had the case was placed on pause with the agency. When the DA did not pursue, then it went back to the agency to pursue how it felt.
For the administrative portion, yes, the internal affairs investigation, it was
When did it
told
go back to the agency?
in 2023.
So it took the district attorney's office almost 4 years to decide whether to file these charges?
About 3 years, yes.
Right, but 3 years, it's 2 months short of 4 years.
No, it went back shortly before then. I believe it's attachment I is the refusal, the DA's refusal in your ISF. That would show you the date that there was
Okay,
a refusal.
okay, so sometime later, we'll average it to have to be 3 years. Now, certainly during COVID, lots of cases lay around and weren't moving through. But, so I'm not blaming any DA's office or anybody else. There was a lot of pausing involved. But the concern of the board, if I can speak for the board, is when he's first asked about this in 2020, he refuses to be interviewed. And then it's not until 12/14 of 2023, the first time that he's ever confronted with facts, audio tape, and transcripts.
That's correct. But I do want to point out that at no time during his interview does he appear to show any fault in his memory. He does
Said he
not.
didn't remember the call.
No, he does not appear to show any fault in his memory as to the conversations between him and the watch sergeant and the watch commander. He does not tell the IA investigators that he does not remember the conversation. He never says that to the IA investigators.
Didn't he say he didn't have a conversation?
No, he says they did not ask.
So let's be sure we're using he's. Okay, when he was in the field, he allegedly had a conversation with the stand-in watch officer that was allegedly taped. So there's a tape of this conversation. When he was asked about it later, didn't he say he didn't remember that call?
No, we're getting a little bit confused here. So when he was, after he had received the MDC messages, he called into the station, spoke with a deputy Strello, who was working dispatch, to ask about why the watch sergeant, whose name is Sergeant Inatel, called or was contacting him. Deputy Strello told him it was because a complainant called in because he'd been stopped outside of a Commerce casino and had had some money stolen from him.
Was that call recorded?
Yes, this is
Okay.
the recorded
Okay,
call.
now tell me what happened then, okay? Recorded call, he was asked about the recorded call close to 4 years later, and
He was asked if he called into the station, to ask about the stops. He said he did not call in. And it was not until he was played that recording that he said he did not remember that call. He was also, however, asked about his conversations with Sergeant Inatel and Lieutenant Easter. And instead of saying, I do not recall that conversation, he said, they did not ask me about that stop in front of Commerce Casino. They asked me about a stop in Montebello.
now are we on the conversation or when he walked into the watch officer's room?
This is when he was walked into the watch commander's office.
And when allegedly there was a screen up and they said somehow referred to the screen and said that call or something like that. I never heard anybody say that the sergeant said the call at Commerce.
No, there wasn't a screen. This would have been a preliminary conversation about a complaint that had come in.
Mhm.
So because there's the public safety officer bill of rights at issue, the watch sergeant and the watch commander would not have made too many inquiries here. They would have simply asked Deputy Robledo, and this is all part of the transcripts. This is
Right.
They asked him, did you make this stop in front of Commerce Casino? Deputy Robledo said no, and they stopped the conversation.
When, this is important to us, who asked him the question, did you make the stop in front of Commerce Casino? And who made it? What time did they make it? Tell us more about that.
So it was either Sergeant Inatel or Lieutenant Easter who asked him, I believe it was Sergeant Inatel. So this would have been the watch sergeant. And this would have been right as Deputy Robledo was coming off of shift. So after he'd received those MDC messages, after he had called in and spoke with Deputy Strello on the recorded line, after he had responded to the MDC messages by saying to Sergeant Inatel by saying, called you, Sarge.
I'm sorry, it must be late in the day. I still don't know when that conversation occurred. Was it the end of his shift?
Yes, this would have been approximately just before 6 a.m.
Okay, so there's no recording of that conversation?
No,
So who remembers them specifically saying commerce?
Lieutenant Easter and Sergeant Inatel.
Okay, so both of them remember him being asked about commerce. He says, I wasn't asked about commerce.
Correct.
I was asked, at that point, is he saying I was asked about some confusion or I was asked about Montebello?
He says he was asked about a stop in Montebello.
Okay, so he was the only one that heard the word Montebello in that conversation.
Correct.
Two other people heard commerce.
Correct.
Okay, where are we, hearing board?
Excuse me, board members, I'm probably speaking out of turn, but if I could just,
Excuse me, no.
so I can't correct the false statements that were
Right,
just,
right now, you're not a part of this conversation.
Okay.
So just stand by.
thank you.
You're welcome. What do you think?
Well, I mean, I think that provides some clarity to some. I don't speak for everybody, but that does, some of my board members, that does, I'm sure, provide some clarity. So.
Are there any, let me ask then if there's any other questions anybody wants to ask the attorney or the investigator about any other confusion that they might be able to help with. Yes.
I'm still in support of going back to further look into this case, even after the dialogue back and forth here. I think we visually needed to see some type of timeline. And although I know we were in 2020, a case, the criminal side of it was sent to the district attorney's office.
Mhm.
I didn't understand why consecutively they couldn't continue the administrative process because so that was the concerning part earlier that was mentioned, and I really didn't think about it, but it was earlier mentioned that at one point it took 4 months for it to ask a question, and we want clarity on.
So your position,
I'm still supporting.
you're still in
first
the
motion.
belief that at this point, you have some questions, you want us to make a record of the questions, you want to continue the motion the way it had been written, and then give it to the commission for the commission to decide what they want to do next. You're in the same position you've been in.
Yes.
Are you?
Yeah, which I think would probably require me to amend my motion.
You want to amend your motion?
Well, I would have to, because I made an incorrect motion.
Okay. You know what,
It
just
was
for the
corrected,
sake-
and I
yeah.
should have been, but
right.
the recommendation would be to send it to the post commission.
Okay, so we're going to start that again.
Okay.
And given all the information you've been given from post staff, is there a motion?
Can I say something?
Yes.
This discussion has been helpful for me, speaking for myself only, has been helpful for me, and I would arrive at a different decision and would not have gone forward with the motion that we went forward with.
Okay. Let's rule on one motion at a time, but thank you for saying that. And so, yes, Dr. Laser.
Just wondering if it's better if we delineate the informational elements that we want and put them into the motion, or if we get the motion and then we provide
The
some.
motion is just for the passing this on to the commission, for the commission to consider requesting further investigation.
Right, but I know.
So
that we
in which
also-
case, that won't be the end of our discussion today. if that motion passes, as I said in chambers, each of you will have an opportunity to say the further investigation that you would recommend that the commission recommend. Okay, does that make sense?
It does. I'm just wondering if it's better
No,
to
I think that.
formalize it in the motion.
It definitely is. Okay, so, yes. Mr.
Just for
Brown.
clarity, so, the motion is put forth and it goes to the commission. The commission then would send it back down to the division. The division would do an investigation and then bring it back to the board.
The commission could do so many things, including they can just decide that there's enough evidence for them to decertify. They
Okay.
could decide to decertify, they could decide to stay, they could do all those things. The commission just gets advice from us, and then they're the ones who make the decisions.
I have one other question.
Go for it. This was all your idea, so go for it.
All my idea, that's.
And it was a good one.
This is for post, you know, it was in the DA, they took a long time. How does that square with POBAR and complete or beginning an investigation before the year?
Right. So under POBAR, an agency is allowed to toll their administrative investigation while there's the possibility of criminal proceedings. And that's what happened here. So they, rather than starting or completing an administrative investigation, they told it. And that's why you have this delay. So once the DA made a final decision, decided they were not going to proceed, that started the time clock, that 1 year provision. And they had to finish their investigation within that 1 year period.
Right, and unfortunately, there's no unreasonableness built into that.
Correct. Yes.
Okay.
And the DA did not go forward because the witness decided not to testify, is my understanding.
The witness decided not to cooperate at some point. Correct.
And I believe there was volumes of information that talked about the efforts that the district attorney's office had made and that he was just not interested. Now, whether that was the sole reason they didn't go forward or not, only the filing DA would know.
You do have that as an attachment to your ISF, their reasoning.
Well, I'm probably not the one to make the motion because I agree with Commissioner Pena. Based on the clarification that I've received, I would be able to vote, so.
So what?
I would be able to vote.
Okay, so let's just do this in order. Does anyone have a motion?
I'd like to make a motion to decertify.
A motion to certify. Okay, is there a second?
I'll second.
Now, roll call.
Okay. Clavo,
Aye.
Clavo, aye. Crawford,
Aye.
Crawford, aye. Doyle,
Yes.
Doyle, aye. Dudley, Dudley, aye. Glacier, Glacier, nay. Johnson,
Aye.
Johnson, aye. Laura,
Aye.
Laura, aye. Pena,
Aye.
Pena, aye. That's 7 yeses, 1 no. Motion passes.
Point of clarification. So we had, didn't we have an existing motion on the floor with a second?
No.
We did.
We never, there was a first, there was a second, then there were questions.
Okay.
But I don't know, do you think we need to do that again? What?
We called a vote. So we did call a vote on the first motion
Okay.
and it passed. So we'd have to have Mr. Doyle or someone rescind the motion in order to take up the second motion.
I make a motion
Sorry.
to withdraw the first motion that I made.
I second it.
Okay. Now we just take a roll on that. Okay, now let's take a roll call on that withdrawal, please.
Clavo,
Aye.
Crawford,
Aye.
Doyle,
Yes.
Dudley,
Aye.
Glacier, Johnson,
Aye.
Lara,
Aye.
Pena,
Aye.
That's 7 yeses, 1 no on rescinding Doyle's motion.
That motion does pass. Well, I, just watching all of you go through this process, it's very clear to me how important it was to you to make sure you had enough information to make a decision. And I admire all of you for taking the time that you needed to do that. So everybody's working very hard today. As that was the last item on the agenda, let me quickly remind everybody about the upcoming board meetings. April 16th through 17th at Post in West Sacramento. At the moment, July 16th and 17th, 2025 in West Sacramento, and October 8th through 9th, 2025 in West Sacramento. As this was the last item on the agenda, do any of the members of the board have any additional comments before we adjourn?
I'm sorry, was that 16?
Sure, July was, the reason I stuttered over it was I heard there was some discussion, but for now, the solid July dates are July 16th through 17th. Any additional comments? Okay, if the attorney is still on the line, we did give you 7.5 minutes to speak. I know you had something more to say, but as the chair of this committee, I felt that we had enough information to pursue what we were doing without any additional information. As you well know, you'll have plenty of opportunity to talk to the commission and potentially a judge as well. So thank you for coming today, and thank you all. I'll need a motion to adjourn for the record.
So move, Doyle.
Second.
Roll call.
What if
Any
we say no?
opposed, any abstentions?
I think we can just ask, is anyone opposed to adjourning?
Yeah.
They're all good with it. So I asked if any of them were opposed to adjourning.
Yeah,
Do we have any
but we
opposition?
don't need a roll call on that?
Probably not.
Okay. Okay, everybody, see you in the springtime.
Thank you.